and wheeling tariff applications. Chair, based on the legal advice received that NERSA has got no mandate to approve SSEG, we would request then to amend the recommendation from seeking committee's approval to rather request the ELS to note the 33 applications. So, Chair, with your permission, we would like to amend the recommendation that is on page 7 of the main submission to noting and not approval. So, Chair, the second batch that we have, we've got 12 tariff applications that are increasing by above guideline or benchmark. These include private distributors, as well as tariffs that are based on negotiated pricing agreements with municipalities and other customers. And then that's listed on Annexure 2 of the submission. And on Annexure 3, we've got cost of supply tariff applications. We've got 4 in total. The first 2 are existing cost of supply tariff applications, which were previously approved by board. These are for George and Diewaterskloof municipalities. And then we've got the other 2, which are new applications that should be considered by the committee. These are for Modimolle and Mokgopong, also known as LIM 368, and then for Nelson Mandela Bay Metro. These are brought for committee's approval. And then, Chair, the last batch that we have is a RFD, or the applications above guideline increase. These are for 4 municipal tariff applications that went through the public hearing process that was held on the 15th of June. These are also brought for the committee's consideration and approval. Chair, just in terms of the delegation metrics, ELS is delegated to approve all increases above guideline, whether within benchmark or above. And then further to this, tariff applications based on the cost of supply studies are also delegated to ELS, as well as existing and new SSEG and wheeling tariffs and reseller tariff applications. So all these are delegated to ELS. Chair, then I think with your permission, then we can start with the first batch on Annexure 1, where we request the committee to note the 33 applications for SSEGs and wheeling tariffs. Thank you, Chair.
Thank you, Madam Mataku. Very well presented. But as requested by Mr. Sichotlo, can we then get an assessment from legal on issues that are raised on the submission, especially in respect of SSEGs and wheeling, please? Mr. Murati, if you can assist us, please.
Good morning, Chairperson, fellow colleagues, and fellow regulator members. Chairperson, I need to tender my apology first in terms of the expediency that needed to be achieved in writing the input, and there wasn't much quality assurance that was done on the input. And between myself and Maria, we went over the weekend to finalize some of the inputs, Chairperson. And in that regard, I would refer members to page 4 of the document, which is, I think there's no green number, it's just page 4. Yeah, page 4 of the document at the bottom on paragraph 4.5. Towards the end of 4.5, there's a word that is second last line there. It says implanting. It's supposed to be implementing. Having said that, Chairperson, one would depart to impress on the members that the demand for compliance is not only generated from the statutory provision when we're dealing with the regulation, but also from the regulatory instruments that NERSA has issued to licensee in as far as the tariff approvals is concerned. Chair, I also need to highlight that the Section 33 of the Constitution read with Section 10 of NERSA Act and Section 4 of PAJA places a fundamental obligation in giving effect to the validity of the decisions that are supposed to be made, because those are considered to be administrative actions in nature. Chairperson, the issue that is before the committee to deal with the SSEGs, because when we dealt with these issues, we needed to also include the issue of the wheeling tariff that is requested. Chairperson, the application before the subcommittee, it's unique in its format. It's unique in its request, because when intensely looked into the submission, the applications the applicants are requesting NERSA to approve a tariff of what should be the price that is charged by the generators, the SSEGs, the small scale embedded generators. But we identified that anomaly of an application could not find space because it's supposed to be dealt with in terms of the Municipal Finance Management Act, because that is what the municipality would actually be paying over to SSEGs, not because the SSEGs will be generating power and exporting it, evacuating it into the municipal grid. So whatever mechanism that the municipality would be utilizing to compensate the generators, it finds its space in the Municipal Finance Management Act, and it cannot be approved at the hands of the municipality. Chairperson, if that is not sufficient enough, there are some other easily identifiable issues that the SSEG that we're talking of, in terms of Schedule 2 of the ERA, they do not qualify for registration. So they do not appear within the regulatory space that NERSA is mandated to deal with. They fall within the administration of licensees. So dealing with these under 100 kilowatts generators that are not registered, it becomes the competence of the municipality as a licensee or the municipality as the network service provider. So it doesn't find, again, homage within the regulatory or the mandate of NERSA to deal with. The second part of it is that, the registered, if they were registered, they were above 100 kilowatts and less than 100 megawatts. The regulator does not approve the tariffs of those registered entities. So by bringing this application by municipalities to the regulator, it is almost the reversing of the decision that is taken, that the regulator doesn't have powers to approve the price or the tariff that these generators will be charging. So there is that anomaly, and it doesn't become lawful when properly evaluated that the idea, the provisions of Section 15 of Section 15.2 of the ERA. It says the licensee cannot charge any other tariff than that approved. But in this instance, the licensee will not be charging. The licensee will actually be paying for the power that it has received from the generators. The third point, Chairperson, that would want to impress to the members is that if 1 and 2 that I've highlighted are not sufficient, this becomes a new generation capacity that the municipality will be receiving from the generators. And there are proper statutory instruments that provides for how municipalities should procure the new generation capacity. One finds that in the new generation capacity regulations, they detail the process that must be followed prior to the municipality procuring the power. So in the absence of that process and completeness of it, the approval of the tariffs that has been applied for becomes premature, it brings the regulatory process, one would call it, into a challenge, because we would be approving tariffs that relates to new generation capacity when we are alive to the fact that the processes that needed to be followed when approving, when considering these generators to be able to supply the municipality hasn't been followed, hasn't been completed. Chair, I would also want to bring to the fore the issue that an attempt to deal with this issue of getting power from other generators without observing the process the attempt was made by City of Cape Town. And the matter ended up in court, and the order was primarily against the municipality that there is no unconstitutionality on the provisions of Section 34. There is no unconstitutionality relating to the new gen regulations. They need to comply, and that has led to the department amending the new gen regulations to include municipalities into the fold of procuring new generation capacity. So based on that, on those submissions, Chairperson, this whole aspect deprives the regulator the jurisdiction to approve the applications that have been brought before it by the number of municipalities. Chairperson, lastly, allow me to deal with the issue of willing tariff, Chair. That the tariff, the willing tariff, it's actually embodied in the EPP, the electricity pricing policy, in terms of the approval of it, how it's supposed to, what are the components, how it's supposed to be charged. And policy position 5 of the EPP requires that NERSA must develop a methodology for wheeling prior to the tariff being approved. And to date, and in my engagement when formulating this view, one was satisfied that there is no such methodology in place. So approving the wheeling tariffs in the absence of a methodology that creates a connection between the electricity pricing policy and the mandate that NERSA has, it exposes the decision to the issues of rationality, less of maybe lawfulness, to say the means that could enable the evaluation of the reasonableness, appropriateness of the tariff is not there. Then it becomes an abstract consideration of such tariff, which may result in no certainty in terms of how does this tariff gets to be arrived at. And it might end up also leading to any person who may want to apply for a wheeling tariff. There will not be a format or a standard that they may need to comply with. They will generate it in a manner that they think it is appropriate for them. So we're saying that in the absence of the methodology that the regulator must develop to enable the formulation of the wheeling tariffs, the approval of such tariffs will be in an abstract. It will not be based on anything that, in the instance that we are challenged, the concept, the issue of rationality, the means to the end that we have deployed could not be sustainable. Chairperson, that will be the input to the document, and I apologize for taking too long, Chair. Thank you.
Mr. Marati, thank you for assisting in this regard. Before I open it to the members, if you can clarify one issue as well, please. You did mention that wheeling is informed not by the law, but is informed by the EPP policy position 5. The question that, if you can clarify that as well to us, is to the extent to which that is binding on the decisions of the regulator, as opposed to the EPP position being a guide. If you can just expand on that a little bit first, please.
Chair, I think it's in two formats that one can deal with this issue. One would be the economic side of it, and the other part will be the legal side of it. The economic side of it is the formulation of tariffs has certain inputs that must be considered, and without a clear guide in terms of which inputs are relevant into the formulation of this wheeling tariff and which inputs should be excluded because they are not material to the formulation of the tariffs, becomes the center of the final tariff that must be brought to the regulator. The legal side of it is that the regulator has issued a variety of instruments. One of it is license conditions. That part of it provides that the tariffs that will be brought, that must be approved, would be based on, for municipalities, is still the municipal tariff guideline. For ESCOM, it's something else. But in the absence of the municipal tariff guideline, factoring in elements that must be considered in approving tariff, then the process towards the approval of it does not have any insulation to generate the protection that one would want. Therefore, one then deploys the application of saying which other mechanism is there that needs to be at play before the tariff is approved. And the policy position 5 says you must have a methodology in place. That instrument is not there. The alternative of it would be a guide that is independently generated, or it would be the rules that must be at play in terms of Section 35. So neither of those instruments are available to deal with wheeling tariff. So the wheeling tariff will just nakedly come to the regulator as is, and the regulator looks at it without a central point of reference. It would need to be evaluated by what is being said in by such an application. So that is a concern that one raises, to say from the nature of administrative action that the regulator is expected to be taken. Process plays a fundamental role in insulating the decisions. Hence, I started with the citations of the Constitution, the NERSA and PAJA. So that becomes an issue of concern that the regulator, if proceeding to take decisions on that, it should be alive to the fact that such decisions, they do not have a central reference point. It becomes an understanding of one member to the next, not having one point that they can all say, this is what it is based on. Thank you, Chair.
All right, thank you. So apologies, just one last one. There is a request that instead of approving those SSEGs that we note them, would we have the mandate legally to even note, and what would noting mean?
I would probably, Chair, let me bring Mr. Choko on this part of the classifications of these decisions by delegation, to say what was the context of what noting would mean. Is noting an administrative action or approval an administrative action? From our analysis is that because there is no jurisdiction on the aspect, the entry of these issues for getting into the level that one would say which decision it's appropriate for noting. Chair, I would have said, and with the apology to my colleagues, I would have said they needed not to even see the light of the day before the committee. Thank you, Chair.
Thank you. Thank you. Madam Maseti, I was going to open to the members. I note your hand. I just thought that it would be useful that we get a full presentation first and then allow the members then to engage. But Mr. Choko, you can come in later, then let me just allow members. In the order, I think that the hands did show up. Start with, I know Madam Pomos is going to leave soon, but maybe can I still start with Ms. Madam Maseti first, and then request you, Madam Pomoso, to then comment. Thank you.
Thank you, Chairperson, and good morning to members. And thank you, Mr. Murati, for the presentation and clarification on how we should proceed on these matters that we need to take decisions on today. My question relates to the wheeling rates that we need to approve as NERSA. I just want to understand, because yes, we don't have this requirement, or we don't have the methodology. However, the methodology, I'm sure it was meant to make sure that the energy regulator exercises its discretion in an objective manner, in a manner that is transparent and predictable, and even in a structured manner. I think that is the purpose of having the methodology. Then I moved on to say that even if that methodology was present, we had it, and as a point of reference in ensuring that we have an objective mechanism that we are going to use as a point of reference, even if it was there, does it mean that we wouldn't deviate from it if there are justifiable grounds to deviate from it? Is it a rule book that we cannot deviate from it, such that even now when we don't have it, we can't exercise our discretion and agree as the regulator to say that, well, we have these wheeling tariffs that are before us. Any delay of not approving them or considering them, what would it mean to the market? Would it not mean that we are, as the regulator is stifling investment here when there's a need and the market is ready to move, and we simply did not do what we're supposed to do to come up with a methodology for this, and therefore it means those investments are now stifled because the energy regulator does not have a methodology. That's the first thing. And the second one is, yes, is it not then, does it not then mean that, this requirement by the EPP, which the regulator did not give effect to, does it not serve as an entry deterrence, a regulatory burden, a regulatory barrier to these investments, because we're not doing what we're supposed to do as the regulator, and therefore it serves as an entry barrier, because it means now we cannot consider wheeling tariffs. And also the third point around it, because these are the considerations that we need to make sure that we pay attention to, does it not mean that we then expose those that are in need of wheeling electricity, because now there is no a rate that has been cleared by the regulator, looked into carefully, and make sure that it is competitive and fair? Is it not something that then from our side it might also come back and put us in a very bad light by not doing what we are supposed to do? That is just my question, Chairperson. Thank you.
Thank you, Madam Masetti. Madam Pungose, thank you for your patience.
Thank you, Chairperson. Just to thank the team and Mr. Moratti for the detailed explanation. I think is laid out, the status and the predicament that we find ourselves in. If I may just ask, especially with the latter matter, which deals with the wheeling tariffs, if indeed, as NERSA, there is no methodology, as we say, there is not, as required by the EPP, there's no methodology in place, and then how do we deal with this thing? How do we respond to the applicants? I mean, do we play open cards and tell them, sorry, due to our tardiness, we have not developed the methodologies yet? Because I take it that the methodology, though it is a guideline, it is it's a regulatory tool that was supposed to be used, to make sure that there's some logic, there's something that informs the tariffs that need to be, to be applied or used, for a certain service. So what is the way forward? Because I think we are creating a problem where we are presenting a predicament. And I do acknowledge that we do not have the power to then set or to approve those tariffs without any methodology guiding us on what are the considerations, the input on all those tariffs that need to be taken into account. However, where to from here? Are we just going to leave the industry in limbo while we're trying to sort ourselves out? And what time period would it require for our team to develop that methodology, taking into account that there needs to be some consultations, to all the stakeholders who will be affected or will be interested in that particular methodology? What is the estimated timeline? Is there an interim solution that we could come up with, to say this is an arrangement we can apply between now until such time a methodology is in place? I know whatever decision we decide to take will be open to scrutiny and may be challenged, rightfully so. However, as a regulator, we need to provide some guidance and direction on how best we move forward. Thank you. And I've also noted the comments on the first item, the applications by the SSEGs, that we do not have, the powers to approve these tariffs. Hence the recommendation that they be noted. And then I will await to hear that input from Mr. Chokwe at a later stage. Chairperson, I will stay in the meeting until 10 past or 10:15. I've excused myself on the other platform and told them I'll join slightly later. Thanks.
Appreciate it, Madam. Thank you. Mr. Mkhize, your input, sir?
Thanks, Chairperson, and thanks to the presenters. From my side, the challenge that I have is that the methodology looking at this legal standing that it is a tool that we use. And therefore, my understanding was that we're then going to look at the principles that will then inform our how we deal with this matter, from the point of view that first of all, let me say that I agree that the recommendation should not be to approve. I agree with that based on what has been put forth. But if we're regulating and approving tariffs, and we know very well that this has got an impact on the tariff, in as much as I always raise concerns with regard to the surcharges, that it can have the tendency of subverting the regulation of the tariffs. And therefore, there is a need to then weigh in on some of these, particularly when one looks at the mega flex, comparing with the mega flex, the SSEG that are coming in, also looking at how this will then impact the tariff at the end of the net tariff at the end of the day. I think there we may not and then echo our concerns with regard to those matters. But what is a bit problematic to me is that we had raised earlier on to the team to say, go and look at all our legislation and publish government policy, and then have a program of the full implementation of the law and publish government policy. And for me, we cannot just put forth this and not say, when are we going to provide a remedy to this? When are we going to then develop the appropriate framework as well as the methodology then or guidelines to deal with the wheeling charges? And that is what I expect then the team to provide. You know, that's why I was thinking that a bulk of the discussion should actually be actually done as part of governance and not in this platform, so to say. That we iron out all those things, and when we come here, there's a clear indication that the right we are noting where we are concerned, we raise our concerns in as much as these charges are impacting on the tariffs that have been set. I will leave it at that. Thanks, Chairperson.
Thank you, Mr. Mkhize. Thank you, members. Can I then maybe, just to complete the cycle, can I just raise my own comments and issues? As indicated, I did actually authorize the release of this document as the FTRM concerned, but I did raise my concern that I did have a conversation with legal, which unfortunately I agree with fully, personally. That firstly, I think the challenge we face is that, and I mean, there's an issue that Mr. Mkhize has been raising a few times around surcharges. The Constitution allows the municipalities to impose a surcharge on any service that they provide. It is not for any regulator to interfere with that. It is a tax, and municipalities have got every legal right to do that. The same also, I think, applies for municipalities procuring any service that will be provided by somebody else. That is well within the mandate it's actually provided for in terms of the Municipal Systems Act, which provides for a development of SLAs as well as, sorry, somebody's mic is on. If you can please mute yourselves, please. Which allows for municipalities to enter into SLAs and SDAs and all that. That, unfortunately, is also provided for in the laws that govern the municipalities as well as the Constitution. That cannot be, unfortunately, be prohibited by any other law. Now, the question that then arises here is that in respect of these SSEGs, is that clearly the municipalities have a right to buy power from wherever that they want to buy from. But of course, the other provisions of their laws come in. The MFMA comes in terms of who you procure from and how you procure from those services, to ensure that the community or the members of the community that is governed by the municipalities are not negatively impacted, as much as the PFMA applies to the national SOEs. So the issue here is one that then says, can we prevent that? The answer to that is no. Municipalities have a right to procure. But the question then arises, as explained by Mr. Murati, is whether the national energy regulator has got the power to govern over the price at which that municipality procures it. And the answer to that again is no, we don't. And hence this question of this validity of, could we actually ever be, why are these SSEG export tariffs then becoming to us? Because if the SSEGs were licensed by NERSA, in which case we would then have, at least in terms of Section 15.2, NERSA would have powers in terms of ensuring that the tariff that they charge is regulated by NERSA. But these are not actually licensed by NERSA, in which case, what is our mandate? So for me, I just thought I would just re-emphasize this coming from the conversation that we have had. So in respect of that, therefore, I think for me, I concur fully with Mr. Murati. But I also concur fully with him that this should not have seen the light of the day, because by noting, it means we're giving ourselves civil powers. The same thing that we've been talking about in terms of Section 9 of the Electricity Regulation Act, with us noting the bilateral contracts, the tariffs between two parties, willing buyer, willing seller. That said, we in noting those things, it says we have this matter should have come before us, and the question is why? Where do we draw the power to do this? This also applies here, but we would welcome Mr. Chokwe's view on this. But I concur with Mr. Murati on that. We cannot even note those export tariffs. However, there are also import tariffs here. It basically the price at which SSEGs buy power. So those clearly, it's when the municipality is selling onto somebody. Clearly, those we need to consider, but not the export tariffs. So that is the one part that I wanted to also talk to. I also want to talk to the EPP. And I think we need to put this to bed. I know that this is in respect of the amendment. There is a clear statement there that says that positions the electricity pricing policy for what it is. It is a guide. It is a guide to the regulator. And therefore the wording as what was proposed by us to DMRE is to say, therefore, the EPP should not have a statement that says the regulator must, because it's only a guide. And therefore, the must gives it powers that may be deemed to be equivalent to that of the Electricity Regulation Act, which is probably incorrect. And this is the matter that really we needed to actually put to bed, that says the EPP can only be a guide. It is not instructive. It does not tell the regulator that you must do ABC. It says in doing whatever that you are doing as empowered by the Electricity Regulating Act, these are the guidelines that you may take into account. But it does not say this is what you should do. Now, I would like to actually, again, if we could, just get firm positions on this in terms of what the actual powers of the electricity pricing policy is in respect of the activities of the independent national energy regulator that is empowered by the 4 laws that created it. So that's one issue that I thought I would talk about. The last issue that I thought is in response to, if you like, the questions raised, very valid questions asked by Madam Pungos. And I don't know whether, and I know that this has been, for some reason, these two processes have been seen as two separate processes. The the electricity pricing, the new electricity pricing methodology that is currently being is meant to go out for public consultation tomorrow, it deals with this issue, because it deals with this issue in the sense that says in the past, all of these willing agreements have really been bilaterals between Eskom and whoever comes, or between a particular municipality and whoever comes to actually ask for those use of system charges. And it's really always been a bilateral. It's not predicated on anything that is universally accepted. That is predicated on a methodology by the energy regulator. This pricing methodology that we're putting deals with that extensively. The actual pricing of distribution or pricing of tariff, or the tariffs that are, of transmission and distribution, is intended to deal with that explicitly in a manner that is actually in a methodology. It may not have been apparent. We thought that it was, but in fact, that's what it's meant to actually deal with. So it's meant to deal with the tariffs across the value chain, for each part of the value chain, of which the use of system is but part of it. So that is one part that I thought I would then raise. So Madam Pungo said, in respect of whether there's where to from here, is that ideally, once we've adopted the new pricing methodology, and we've been able to then come up with these distribution charges and transmission charges, and those become clear and transparent above the board tariffs, that anybody that needs to will electricity, those are the charges that will then be applicable. So I'm really hoping that basically I was just trying to raise this issue together in terms of the conversation that we've had with LAS, but also then as I hand it over to primarily, I guess, LAS supported by Mr. Chokwe, to then respond to the questions that have been asked by members. Over to you, Mr. Murati, also supported by Mr. Chokwe. Maybe, Mr. Chokwe, you can start in respect of the other issue of noting whether can we even note those items when we actually don't have a mandate to do that, Mr. Chokwe. And then, of course, Mr. Murati can assist with the rest of the questions.
Good morning, Chairperson. Good morning, members and colleagues. We indeed have no business to note these decisions when we don't have the power to actually really take a decision as in administrative action, because there is no basis in law. But I should indicate that I'm not actually trying to run away from responsibility. This is the work that we got from Mr. Murati and their team, ELR, when we said, what are the type of tasks that you guys do? Tell us and to indicate how you want this thing to be resolved. But we agree that indeed, this noting, it initially looked like it was just in a very light way where members would just know what's happening, but we have no business to be part of this noting, Chairperson. I would stop here. But maybe on a lighter note, I heard Mr. Gumede saying he's concurring with Mr. Murati. Let's allow only lawyers to concur. Other people must just agree. On a lighter note, Chairperson. Thanks.
Okay, great. Understood. My learned friend. Okay, Mr. Murati, over to you.
Chairperson, thank you very much, and thank you, members, for the inputs and questions. And I think one needs to appreciate that the level that they assist in enhancing future drafting of documents that comes before the subcommittee. That is appreciated, Chairperson. I think let me start with the issues raised by Madam Maseti. There is this principle in law that you only exercise discretion when you have something that informs the exercise of the discretion. And I'm starting with that part to highlight the issue that for an administrative body like NERSA that is supposed to be implementing what the law has mandated. The discretion could only be exercised from what the law has given. And in this regard, with the SSEGs, that mandate is not there. So the question of discretion does not even arise, because when we start trying to exercise discretion over the SSEG, one would be concerned with the aspect that we actually extending the mandate of the regulator, because exercising of a discretion, it's already on a power that you have. So we cannot exercise that. And deviation from a methodology, and you're very correct, Madam Masheti, that when you have a regulatory instrument that has been developed, you can easily deviate from that methodology. And that has been supported by Judge Colapen in one of the ESCOM cases, to highlight that the regulator can deviate from the methodology that it has developed. In the SCA case of Bobet, the SCA confirmed that ability to deviate from the methodology, but they put a proviso to it that such deviation should be informed by reason, and that reason should be lawful and rational. So there are conditions precedent the exercise of deviation from the methodology. In the absence of that, you have to implement the methodology as is. So there is this mixture of things that comes into play as we are an economic regulator, to highlight the issue that are we not stifling investment and all sorts of things through to that economic aspects of it. But in meeting that, we need to be within the frame of what the law enables us. So we should be very cautious in looking at as the mitigating factors in deviating from the said standard or the said methodology. The market would be in the aspect of in the issues of willing. There are two dimensions to it, the chairperson. One is drawn to look at it from a regulatory approval point, and also an operational administrative point of licensees. From a regulatory point, one would want to have a uniform way of dealing with the consideration of the tariff, not necessarily the number, but the inputs to it, that there should be uniformity. And that generates that regulatory certainty that we have always advocated for. But the operational administrative aspect to licensees comes into play in that this willing takes place under the auspice of a connection agreement that needs to be signed by whoever needs to wield the power. So the licensees do enable the connection, and ERA, Electricity Regulation Act, in section 21 or somewhere there, it makes it obligatory on licensees to allow access by third parties, and it can only be refused on objectively justifiable grounds. So the regulatory aspect dovetails that part, because it now deals with the tariffing aspect. But the technical side of it, the law has dealt with it to say, as a licensee, you can only refuse if you have an objectively justifiable ground. So the market has a safety valve that it can deal with, and if the licensee refuses, there is also the issue of compliance enforcement. There's issue of dispute resolution that can come into play to deal with this issue. Chair, coming to Madam Bongwa's question, which Chair you have tried also addressing it. How do we respond to the applicants that to date have made an application? Chair, it's one of those that I think I'm more inclined to what Mr. Mkhize has highlighted, to say maybe this part of the discussion, maybe if we were having it in committee to deal with, so that we explore everything else before we venture out to make finality to it, because one would need to explore internal issues in terms of responding to that particular aspect. Yes, we are seized with an application and the regulator must take a decision. But I think some of the aspects to it, that the inputs to it would require an in-house consideration. That would be my way of responding to that. It might not necessarily deal in detail with the issue or necessarily answer the question that Madam Bongo said, but I'm concerned about part of it, part of the input to it. The same as the issues that Mr. Mkhize have raised. They become part of the in-house considerations that we need to be alive to. And Chairperson, coming to one of the issues that you have raised, you have raised an issue that the next submission touches on this, the interrelation between the mandate of the regulator, the provisions of the ERA, and the EPP. How do they have a connection? And how does that connection translate into the ability of the regulator to enforce? So, Chairperson, that issue, I think we can deal with it when we address the next submission on the next submission. Thank you, Chairperson.
Mr. Mrati, we are actually dealing with both. So if you can just maybe deal with that, and then I'll open up. I know we've been at this for an hour now. We have not even looked at the single application before us, but I think these issues are pertinent. So we'll give it another maximum 15 minutes, 10 minutes, and then we close on this. But the next submission is also up for discussion. So if you can respond to that, please. Both were introduced. That's what I'm saying. Ms. Matlaku actually introduced both submissions.
My apologies for slowness, Chair. I've been heavily focused on just one application, so I think there's parts that one would need to get in detail into dealing with in response to the comment that you have made. Chairperson, the issue that comes into play with the question that you have raised and touching on the second submission, the one regarding the municipalities that we have dealt with in terms of the RFD. I think are you referencing that, just to be sure that I don't talk before you? Are we also dealing with the one that has an RFD?
Madam Matlaku, would you care to assist? Because I thought we had introduced both, so that at least we are clear.
Yes, Chairperson, that's correct. I think it would be proper to just deal with that as well, because they're all, although they're made as two separate submissions, but it's actually all dealing with tariff applications. So I think it would be proper to just deal with that as well. Thank you.
Thank you. Mr. Mrati, there is actually one submission that introduces both. I know the other one is more about the RFD, but it's RFD of the tariffs, because there are certain decisions there that have been made based on the previous applications, for instance, in terms of cost of supply studies. So yeah, it actually deals with both.
Thank you for the guidance, Chairperson. Maybe one would need to highlight in terms of the question that in a broader way, to highlight that the ERA as an enabling legislation exists independent of the electricity pricing policy. But the ERA generates a joinder through NERSA. The ERA does not generate a joinder on its own. It generates a joinder of the electricity pricing policy through the existence of NERSA. And that is achieved through section 41A4 of the Electricity Regulation Act. And just for expediency, it mandates NERSA it must develop rules to implement the policy. That is where it starts. And the APP again on its own does not, which is the same as the aspect that I've read, that it does not enjoy the regulatory effect on its own. So the industry is not bound by the EPP on its own until such time that the regulator has generated those rules. Yes, there are exceptions to the EPP when it comes to the regulatory space, and that relates to issues of the NPAs. It refers it back to the department. But when it closes that provision, it demands from NERSA to do something so that the NPA process can be completed. Chairperson, I also need to touch on the aspect, if you can just give me 3-4 minutes, that when you look at this whole aspect of the tariffs that the regulator is considering that are above the guideline, in the past, there's been a demand from NERSA that those applicants need to submit a cost of supply aligned with that adjust. Something is happening here.
It's not on your side?
No.
Okay. Members, colleagues, please make sure that your mics are off. Honestly. Thank you. Please proceed, Mr.
I would wish to have a small baby in the house, but there's none, Chairperson.
Oh, okay. Right. Please
so,
proceed.
Chairperson, this issue of including the demand for cost of supply to be included with the application, it raises two issues. One is that the applications that comes before the regulator, they have been brought in terms of what the regulator has issued, which is the municipal tariff guideline. And one can be settled that the municipal tariff guideline, it is not a standard that is required by the EPP when dealing with the cost of supply. It's also not a rule in terms of section 4 that I've cited of the Electricity Regulation Act. So these applications that comes above guideline, they are limitedly related to the process that the regulator has started. The regulator cannot, in the instance, invent a process halfway through to say, as an applicant, you need to also bring this to the process when that process did not form part of the whole process when it originated. You sit with a situation where the as I said, that the guideline is not a rule or a standard. When you look at the policy position, electricity pricing policy position 23, when it comes to deal with the issue of the cost of supply, it places an obligation on NERSA over and above the provisions of section 4 of the ERA. It says the regulator must develop a standard for the licensees to be able to do the cost of supply. So, hence I started with the aspect that the issue of the EPP, it's such that the joinder, it is through NERSA for it to be finalized. The municipal tariff guideline sets out its own distinctive process. It highlights those that are within the guideline and benchmark. Then it highlights those that are outside of the guideline and benchmark, that they will follow a separate process. So the municipal tariff guideline sets out that process, and these applications are brought in line of that provision of the municipal tariff guideline. They are not brought outside of the process. So it is appropriate for the regulator to consider these applications within the realm of the guideline that it has approved, the guideline that it has consulted on, instead of introducing the provisions of the policy as if they have a forceful effect on their own, outside of the dictates of the ERA, outside of the dictates of its own provisions in policy position 2023. Chairperson, there is also a fundamental issue that one needs to address before the subcommittee. That is of the issue of the public hearing. Despite the guideline giving effect of the demand for public hearing of above guideline, that provision kind of generates maybe a little bit of, one would say, a distortion to say it is not the municipal tariff guideline that demands that part of the process. That is the process born within the valid administrative action taking process. The Constitution, NERSA Act, and PAJA, they demand that for a valid administrative action, you must have a procedural fairness process. So this guideline just gives effect to what has already been demanded by law to be done. So lastly, Chairperson, the issue of the applications that are coming through, and I've emphasized it at the beginning. The issue of these tariffs that are being considered, one might be tempted to ask that, are we not approving a surcharge? And one, you have touched on the issue of the surcharge, that it derives from the Constitution empowering municipality to develop processes to build the surcharge. And the Municipal Fiscal Powers and Functions Act empowers the minister to develop the norms and standards that must enable the municipality to do a surcharge. The Municipal Systems Act enables municipality to charge a surcharge on any service that they would have provided that is being rendered by any other person. But in this regard, this process doesn't meet that aspect, because the aspects that are being brought before the regulator, they are aspects that are within the mandate. They relate to the aspects of issues that are within the regulator, and that were generated by the municipal tariff guideline. So they are not divorced from the entirety of the process. The only difference is that the regulator needs to evaluate the reasons advanced by the applicants, determine the reasonableness, the validity, the fairness of it, and in the public interest, conclude on them within the aspect of tariff approval. They are not outside of that. Thank you, Chairperson.
Thank you. Mr. Ntanzi, I note, apologies, by the way, colleagues, we've taken a long time on this. Mr. Ntanzi, your guidance, please.
Chair, thanks. Chair, I think whilst the committee is engaging on these matters vigorously, I'm of the view that the issues can be better considered in a closed session or a workshop mode, Chair, so that whilst we are learning and sharing information, this does not happen in an open meeting. That would be my view, Chair. I'm raising my hand in support of what Ms. Masset is saying. I think there's benefit in what is being shared, but it can best be considered in a closed session. Thanks, Chair.
Thank you for the guidance. I noted both that it was also something raised by Mr. Mkhize as well. I guess the issue is, to the extent, Mr. Ntanzi, we need to make decisions today. And I am also aware from Madam Maseti, I'm not sure that I still see Madam Pungos is still on the call, but Madam Maseti had indicated that she's under load shedding and we may actually lose her and maybe lose quorum. But the issue, I think, for me was that to the extent to which we have got these applications before us, how do we deal with them? It's that. So I guess we could have made a call at some point to close the meeting and discuss it. But we do need to now proceed with these applications, and perhaps then request that we have a follow up. Thank you, Madam Pungose. Thank you for staying on for longer than you had thought you would. But I'm not sure whether we actually still correct, by the way, for us to continue. Mr. Mkhize, your hand is up. But I think I'm actually seeking guidance in terms of how do we then proceed in terms of making decisions today. Mr. Mkhize first, and then maybe Mr. Ntanzi, you can assist. I'm not sure if Madam Maseti is still on the call.
Thanks, Chairperson. I think that the rest of the issues can actually be dealt with in a closed session in terms of paving the way forward, how best to deal with these issues, how then the review of the methodology, etc., will contribute to properly delineating these matters. For me, however, today is a question of, do we note or don't note? And we live with this as being outside of our purview, just like that. Because I was thinking that there was still going to be an explanation of noting what would it entail, because whether we've got to anything to do with it. The one suggestion, one input by Mr. Choko was saying that we don't have any business to be noting. So for me, it's just for us to vote on that and we close on this matter and proceed before we actually find ourselves not having a quorum.
Thank you, Mr. Mkhize, but I suspect we don't have a quorum already. Mr. Ntanzi?
Yeah, Chair, thanks. I think in your own assessment as the chairperson of this committee, if there will be further need for clarity on these issues, I think the meeting can be closed, Chair. But if the subcommittee is ready to take a decision, by all means, I think we can proceed and wind up the business of today. Thanks, Chair.
Thank you. Mr. Ntanzi, thank you for your guidance. I think the challenge we are facing is that it is the 29th today, so it's not like we have another opportunity, I think, to proceed, because we need, municipalities need to have a decision for implementation on the 1st of July. So we do need to proceed today, but I'm just not too sure whether, firstly, do we correct still? I can't see Madam Maseti, because Madam Pongos has indicated earlier she's had to excuse herself. We really appreciate her staying a whole lot longer than she thought that she would because of prior commitments. So that's the first one, do we correct? Because if we don't correct, then I don't know how we proceed, Mr. Ntanzi. That's number one. Number two, I think we do need to have maybe then also further guidance from Mr. Mrati here. He had indicated earlier, but I don't know whether we put it to a vote as members in terms of do we note or don't we. Perhaps all that legal could do is guide us, but we can then put it to a vote and to see whether we can note those export tariffs. But if we correct, so the fundamental question is, do we still correct? Mr. Mkhize, I see your hand is up.
No, sorry, it was a lingering hand, but maybe if you can just check with Madam Massetti if she's available, because if she's available, then we correct and we move quickly to dispense of these matters. Meanwhile, maybe a clear another explanation could come up from Mr. Bonseni, Advocate Murati, in terms of whether we note or we don't note, and we leave it at that. That it is in their purview, and we don't have any powers over that.
All right. Mr. Murati, if we can maybe have a final word on this. Mr. Dlamini, if we are as Mr. Murati is still is going to bite us again in terms of whether we note or those should not have even seen the end of the light of day. Can you please check with Madam Massetti? I know she had a challenge. Can you kindly check if she can still join?
Chair, to answer you, we don't correct. At the time when Ms. Mpungos was around, we were correcting, but for now we can't take decisions. Thanks.
Okay. Mr. Murati, please then assist us, please. Whilst Mr. Dlamini is still checking on Madam Massetti.
Chairperson, I think we can note it, and I've consulted with Mr. Chokwe that we can note it. It doesn't have any effect on us. We just note it to say that the noting seems to be, from what I got from John, the noting it's a general recognition of work done. It's not an administrative. It's not a rejection or an approval. It doesn't equate to that. It's just appreciating the work that has been done on it. So noting will be correct, Chairperson.
Okay. No, thank you. All right. Madam Massetti had sent a message to say that her battery had run low, so she's making a plan to reconnect. Thank you, Madam. So now at least we now correct. Madam Massetti, as we join, we're just agreeing that we can note. There has been a request also by the team that we do note those export tariffs, but we're not going to go into any details of them. The noting will not have any impact on us, so it's just noting that is at least that we've read the documents as presented before us, so we can proceed in that manner. Members, I know that with load shedding it is a challenge. Thank you, Madam Massetti, for coming back. So we have an hour and a half to now go through these documents, but especially now that we are only noting, can I then, unless there are any other questions relating to the submissions then before us, that other things that we cannot deal with in a closed session or in a workshop mode, if there are any other issues, if not, can I request that we now go straight into the matters before us, and we note those that need to be noted, and so that means we can go very quickly as well. With your permission, members, if we can then go straight into the first application, which is Beaufort West, presented by Ms. Pumla Botha, unless, of course, there are any further questions from members. And I'm also hoping, members, that we've dealt with the overarching issues and that we're only going to really deal with each of the applicants in detail only if there's something very peculiar about that and it's outside of the things that we've discussed. Yes, Madam Atlaku, so your hand is up.
Yes, Chair. Just to indicate that the all other submissions would start then from Annexure 2 and not with Beaufort West, but rather with Acacia Operations Services, ACI. The Beaufort West is actually part of the SSEG, so we then need to move to Annexure 2, starting with Acacia Operations.
Annexure 2. It's on page. Sorry, I note your hands, members. It's on page of page 784. What page is it?
Let me quickly just check with that, Chair.
All right. Whilst you're still checking, Mr. Mkiza, your hand is up.
Chairperson, Chairperson, I'm suggesting that we've agreed that we are going to note this. There are overarching issues that were raised. The matter is still going to be workshopped, so to say. We note all of this. If we can, by exception, deal with the issues that are were found peculiar or troublesome from our, or concerning, from our side, maybe those may be raised. But I'm of the view that we note these submissions, and then we can just read out all of them as just to put them on record that we have noted them, so that we can be able to move quickly with the meeting. That is my suggestion. Thank you.
Thank you. So if I can get your the suggestion more succinctly, Mr. Mkhize, what you are saying is that rather than going through them one by one, we just go to the list and indicate all of the municipalities for whose SSEG tariffs we've noted, just by name, read them onto the record, and that be it. Is that what you are suggesting, Mr. Mkhize?
I'm suggesting that the same way that we deal with registration of SSEGs. Thank you.
All right. Thank you. Thank you. Madam Maseti?
Thank you, Chairperson. Chairperson, since we have lost about 1 hour, 30 minutes, and we also don't want to be on record having not properly considered the matters that are before us today, yes, we will probably apply ourselves to all of these matters, but I wanted us to perhaps agree on the principles so that the proceedings run smoothly in terms of these increases that are above benchmark or that are above the guideline increase. What are the key principles for the team to make sure that they make it easier for us to then make a decision? For instance, should we agree upfront what we are going to consider, whether the benchmark increase must be based on cost, must be justified by cost, or should we also be guided by inflation? If so, on what basis? So that they indicate very quickly those kind of things. They must also make sure that in terms of the reasons, they put them clearly on each of the tariffs, not the issues that we had yesterday. Otherwise, it becomes a problem if we take a decision on the reasons that are given, which are not proper, and also to indicate if there are no new tariffs that are added in all of these applications that we are looking at. Because if that is the case, it would have required us then to have a cost of supply study, which the regulator must properly consider and approve. So we all depend, again, Chairperson, on the team here today, but at least for us, let us agree quickly on the principles so that we facilitate the smooth running of the remaining part of the meeting. Thank you, Chair.
Thank you, Madam Maseti. Okay, from what I'm saying is that if colleagues, we go back to the submission, so there were 3 decisions that were sought from us. The first decision was in respect of SSEGs and wheeling tariffs. What we are agreeing on there is that we are noting, and we can read all of those items, and then there are issues that are relating to, and we can read them out in the same manner as we normally read, as in the manner that we deal with SSEGs. Then secondly, there is Annex 2, which is now those applications that are above guideline. And what you are suggesting, Madam Maseti, is that you need to get positions on that, overarching decisions in terms of how we deal with that. So the team will present to us what those issues, if there are particular issues, or how they should assist us in dealing with those, starting from Acacia. So that's what Ms. Matlak was indicating. But what I'm saying, unfortunately, there is only one submission for us, and it's got 784 pages. I was just asking that we be assisted in terms of the page number where that Annex 2 is starting. And then, of course, clearly we'll then deal with Annex 3 issues. Again, if maybe before we go into those, the team can then assist us in terms of the decision-making framework for Annexure 3, which are the cost of supply tariff applications. So those are the three decisions that we've been asked to make. So the first one, as suggested by Mr. Mkhize, is that we make a decision to note, and then I read all of those onto the record. So can we start with those, colleagues? Mr. Mkhize, your hand is still up.
That's I support that. As I put it forth, if we can deal with the first and second one, then the third one we deal it as you had outlined.
Okay.
Also supported by Madam Massetti. Thank you.
All right, thank you. So, colleagues, can I then ask in respect of the first recommendation, which is for us to note all of the SSEG tariffs and willing SSEG tariffs as well as willing tariff evaluations as presented in Annexure 1. By show of hands, members, if we can note that. Thank you, Mr. Mkhize. Thank you, Madam Massetti. I also support. So can I then read them onto the record which of those SSEG tariffs and SSEG and willing tariffs that we are noting? We are noting firstly Beaufort West. We are noting Bito. We are noting Brieda Valley. We are noting Cape Agalas. Also noting Cederberg municipality. Also noting Drakenstein. Noting Hessequa. Noting Neisner. Langeberg. Matsikama. Mossel Bay. Wortshoorn. Overstrand. Prince Albert. Saldanha Bay, Swartland, all those are in the province of they're in the Western Cape province. Coming to Gauteng, there are three that we are noting: the city of Tshwane, secondly City Power, thirdly Mohale City. In the Northern Cape, we are noting Mthanjeni, Hunter, High Karib, Salt Blackie, and Ubuntu. In the Eastern Cape province, we are noting Buffalo City, Kucha, and those two. In Free State, we are noting Mafube. In KwaZulu-Natal province, we are noting eThekwini Metro, Msunduzi, and Ulundi. Limpopo, we are noting Ephraim Mohale. And in Mpumalanga province, we are noting Emalahleni MP and Govan Mbeki. So those are the ones that we are noting in terms of SSEGs. I thank you, members. So now if we can be guided, Madam Matlaku, where does Annexure 2 start? Which page does it start? And also if we can also introduce at a high level the issues at play here.
Thank you, Chair. Yeah, so Annexure 2 starts from page 308 of the submission. These include, there's 12 applications that are increasing by guideline or benchmarks This also includes private distributors, Chair, and it would also include some of those tariffs that are based on NPAs with municipalities and other customers. Chair, I'd just request that the team, as they present those, just to indicate and highlight those issues that were raised by Ms. Massetti. Thank you.
Thank you. Is it not possible for expediency that maybe there may be overarching issues, Madam, that you could introduce first? So let's agree on principles so that we don't deal with this one by one and then have to deal with each of them. So is there, in the high level principles, for instance, let's just take the ones which are linked to, which are based on a bilateral between Eskom and a particular municipality, and therefore the increase of that tariff is linked to the Eskom tariff increase. Those kind of principles, Madam.
Okay, Chair. Just to maybe highlight that those that are private distributors are not necessarily based on or does not go regarding the guideline increase, because with private distributors they use a different cost structure and not necessarily aligned to the 7.47 increase like the rest of municipalities. Yes, we've got, I think, 3 municipalities that have those tariffs that are based on NPAs, either with Eskom or with other customers, and the nitty-gritties and details of that, Chair, I think that the colleagues can highlight. I don't have the finer details regarding the specific municipality or the specific licensee that will be presented. So I'll just ask maybe the colleagues to highlight a bit on those as they present. Thanks, Chair.
Thank you. Thank you, Madam. Okay, can I then request members that we, just for expediency, that we will tackle each one of them, but once we've dealt with the principle on one, then the principle will then apply to the ones that then follow. But we'll deal with them because I guess, as indicated, there are some are very unique from others. The issues related to independent distributors is very different to those relating to NPAs. So can we proceed that way and get the first presenter, Ntabiseng Mapiti, to present Acacia Operation Services, please.
Thank you, Chairperson. Good morning, everybody. Acacia is a private distributor. It's applying for 7.47. The private distributor purchase electricity from eThekwini Metro, and the tariff compare well with the eThekwini Metro, Chairperson. Recommendation is on page 314. Thank you.
Thank you. I think this one is a bit more straightforward. Members, what do you say? Any questions first of clarity? If none, by show of hands, members, can I see if you support the recommendation is on page 314. Thank you, Madam Massetti. Mr. Mkhize, would you support the recommendation? Thank you, Mr. Mkhize. I also support. You've got your decision there. Can we then get Dumplus?
Thank you, Chairperson.
Thank you.
Thank you, Chairperson. Dumplus is a private distributor which is based within Ketwana, local municipality. Dumplus is applying for 7.47%, which is the guideline for the current financial year. And then Dumplus, with the financial indicators, it's doing very well. The surplus and all the benchmarks, all its indicators are within the benchmarks. And then I therefore recommend for approval, Chairperson.
Thank you. Thank you. Members, any questions to this on this one? If not, by show of hands, members, if we can, if we support the recommendation on paragraph 7.1. Thank you, Mr. Mkhize. Thank you, Madam Massetti. I also support. Can we then move to Itala Finance? Mr. Manda.
Yes, thank you, Chair. So Itala is applying for a 9.61% increase in line with the Eskom increase, and all of its tariffs are within the benchmarks as well. Thank you, Chair.
Thank you. But maybe, Mr. Mandla, you do need to then deal with this one because it's 9.61. So either the previous one was 7.47, but this one's 9.61. If you can just talk to that a bit before I open up to members.
All right. Yes. No. Thank you very much for that, Chair. So this one, as I indicated, the increase is in line with the ESCOM increase, which was 9.61, not the ESCOM increase to municipalities. And its increase is based on its costs. These are provided in page 319. It shows that the costs of according to its costs, its increase in cost is going to be 9.78. However, it is applying for a 9.61 increase, which is in line with the its increase in bulk purchases from ESCOM, Chair. I don't know if I dealt with that properly or there are any further questions.
Thank you. Well dealt with. Madam Massetti, your question, ma'am?
Chairperson, can all presenters just indicate that increase? Because if they talk about within benchmarks or within guideline increase, so why did we bring this to the ENS then, instead of dealing with them at the REC? So they need to zoom straight into that increase or the increases that are above the benchmarks or above the guideline increase, state the reason thereof why they're above, and also state the impact in terms of them now assessing and being satisfied that they can be allowed. Just on those three things, then we can be able to move smoothly, Chairperson. Otherwise, then it becomes a problem if they simply say they're within benchmark, they're within guidelines. So why did we take them out of the REC then and bring them here? Thanks, Chair.
Thank you, Madam Massetti, for that enhancement. So members, so colleagues, as you present, please take the guidance into account. That was meant to guide. If there are no further comments, members, or questions on this, if it's clear enough, the 9.61, its origin, can I then take it to the decision that is sought on page 325? The decision, the recommendation is 8.1. By show of hands, thanks, Mr. Mkhize. Thank you, Madam Massetti. I also support the decision. Back to you again, Mr. Mandla. Again, it's Itala.
Yes, thank you very much, Chair. This is Itala again with its other with the other areas that it supplies. Again, it is applying for a 9.61 increase. Again, this is based on its cost. It's in line with its bulk purchases cost from ESCOM, and the recommendation is on page 331. Thank you very much, Chair.
Thank you. This one is similar, members. Any questions? If not, by show of hands, members, can we approve this one? By show of hands, thank you, Mr. Mkhize. Thank you, Madam Massetti. I also support approval. The next one is back to you, Madam Mapiting.
Thank you, Chairperson. Here we've got SASO. One is SASO. I'll appreciate if I can present them both. It's SASO Berg and SASO Secunda, which applies for percentage of 9.61. The tariff compares well with ESCOM Megaflex. They buy directly from ESCOM. Chairperson recommendation is on page 335 and 348, respectively. Thank you.
Thank you, Ms. Mapiting. Members, any questions on both of these? If not, can I take you to decision on Sasolburg, which is on page 335? Can I see? Okay, there is a question on the chat, Madam Mapiting, if you don't mind. So the application is for 9.61, but if you can then maybe explain again in terms of how that talks to the cost of acquisition. Mr. Mkhize, your hand is also up. If you can maybe ask your question as well, sir. Oh, you are voting. Apologies. Ms. Mapating, can you please just respond to the question that was asked on the chat by Madam Massetti, which I think I've tried to.
Okay, thank you, Chairperson. I was trying because I was connected to the phone. We had a load shedding. However, the SASOL Sasol advised Chairperson that they mirror the same Eskom Megaflex tariff in order to provide for the customer. However, they stated that their customer has a choice to either be supplied directly by Eskom or not. Yes.
All right. So what we are saying is that the cost, whether supplied by Eskom or supplied by them, is already, the cost are exactly the same and the increase is the same. Is that what you are saying?
True.
All right. Thank you. All right. With that, members, can I see a decision? The decision that is sought is on page 335 for Sasolburg, for the Sasolburg area, by a show of hands. If you support the decision there, thank you, Madam Massetti. Thank you, Mr. Mkhize. I also support. The next decision is it's the same client and a similar situation. The next decision is sought is on page 339. By a show of hands, members, would you agree to that decision? Thank you, Madam Massetti. Thank you, Mr. Mkhize. I also support the decision. You also have the third one that you didn't talk to, Madam Mpiting. It's the Sinfield one, the private distributor. If you can talk to that as well.
No, Chairperson is the same.
It's the same.
It's the same. It's Sasol Sinfuels, but then one is Sasolburg, one is Secunda.
Okay, maybe I got it wrong. Okay, apologies for that. Makes sense.
Thank you.
Thank you. All right, so let's move on to the next one, which is, I don't know, lost track of what I was trying to say here. So Secunda, Sinfuel, it's all Sinfuel. Okay, so that one is on page 348. That's why you confused me. Okay, the next one is Dr. Konjelayo, City Power.
Yes, good morning, Chair. Good morning, members and colleagues. So City Power has two special pricing agreements with Ekurhuleni as well as AEL. So they are supplied at, so the tariff is benchmarked against the Eskom Megaflex plus a markup of about 10% for both tariffs. So because the Eskom Megaflex for municipalities increases by 8.61%, we are also recommending the approval of both these NPAs based on the increase of 8.61. Thanks, Chair.
Thank you. Any questions, members? If not, the decision that is sought is on page 358. By show of hands, members, if you agree with that decision. Thank you, Madam Massetti. Mr. Mkhize. Thank you, Mr. Mkhize. I also support. The next one is Ms. Matumbu Drankenstein.
Thank you, Chair. Drankenstein has an agreement with Stellenbosch, where Stellenbosch is buying electricity from Drankenstein to supply its customers, which are located in the Drankenstein area. So the increase is in line with Eskom's increases of 8.61, and Stellenbosch is in agreement of this. And to touch on what Mr. Mkhize highlighted at the REC, that is this agreement in line with the above guideline for Stellenbosch, and we contacted the municipality and inquired with them, and they did indicate that building a substation was part of their guideline, them applying for above guideline, and them building the substation is for them to take over the customers, which it's currently supplied by the electricity board from Drankenstein. So we therefore request for approval. Thank you, Chair.
Thank you, Madam. Any questions, members? If not,
Chairperson. Yes, Chairperson.
Thanks, Madam. Please go ahead.
Chairperson. Thanks, Chair. Chairperson, to make things easy, and I'm repeating this, I don't know, maybe it's the third time now. can just presenters indicate that cost of increase? It doesn't help us to say they're buying from Dragonstein or whatever. Dragonstein is selling to this one, and therefore they are comparing with Eskom's tariff and all of that. We don't get the link properly in terms of the reason. Can it be stated what is the cost increase to the municipality, which then requires the municipality to come to NERSA and say, oh, if we stick to your guideline increase, we will not be able to recover our cost. And therefore, we will also compromise on our markup or the net profit. Can we be presented in that manner so that we can see those facts that are before us? Otherwise, we are struggling here, Chairperson, at least from my side, Chairperson, to justify the decisions. I want to support all the way, but then I really struggle if, the information that comes out and we can't even see it properly in the submissions. Can everybody please just put that critical question and also show that you have considered the impact on customers for you to be satisfied that the extent of this increase is justifiable and can be allowed if one considers affordability. That's the way that we should take these things, Chairperson. Thank you.
Thank you, Madam. Mr. Tumbu, can you please assist? And also, please, the presenters that are coming after to also indicate as such as been requested by Madam Maseti. Ms. Matumbo, can you assist?
Thank you, Chair. In terms of how customers are affected by this, that can be dealt with under the Stellenbosch application. This is an agreement between Drakenstein and Stellenbosch, where they agreed to buy electricity. Stellenbosch agreed to buy electricity from Drakenstein. So the cost is to the municipality, not the customers. Thank you, Chair.
All right, maybe we can expand a little bit on this one to assist you, Madam. Madam, is that in essence, this is it's a pass-through of the bulk charge. The bulk charge from Eskom is 8.61, and they are translating that bulk charge, the charge through to Stellenbosch, correct?
Correct, sir.
All right, thank you. All right, but please, colleagues, please assist with the decision making and indicating linking the costs to the increase in the cost to the increase that is sought from members. Thank you. With that decision, with that explanation, Madam Maseti, members, are you able to take the decision that is recommended on page? Yes, it's noted on Madam Maseti, that is very correct. Are we able to take the decision that is sought? It's on page 363. By show of hands. Thank you, Madam Maseti. Mr. Mkiza. Thank you, Mr. Mkiza. I also support. The next one is back to you, Mr. Mandla. It's Kwadubuza.
Yes, thank you, Chair. So with this
please, before you do, Mr. Mkiza, lingering hand, or you wanted to say something before he proceeds?
Lingering.
Oh, okay, all right, thank you. Apologies. Please proceed, Mr. Mandla.
Yes, thank you very much, Chair. So with this municipality, Kwadukuza, most of its tariffs were approved in the REC of 20 June. However, this one tariff, which is an agreement between the municipality and SAPI, was brought back because it's increasing by 8.61, which is in line with the increase to the municipality from Eskom. And this is on the basis of an agreement between, as I've already indicated, SAPI and the municipality. And this tariff only affects SAPI and no other customer. So SAPI submitted a letter indicating that indeed this is how the agreement works between it and the municipality, that it will increase by the increase to the municipality from Eskom. Thank you very much, Chair. So I recommend that the 8.61 be approved as applied for by the municipality.
Thank you. I think that's very well presented. Members, any questions? Further questions? If not, can we then move to the decisions on page 370, paragraph 10. Thank you, Mr. Mkiza. Thank you, Madam Maseti. I also support the recommendation. The next one, back to you, sir. City of Mhlathuze.
Yes, thank you very much, Chair. So City of Mhlathuze is also one of the municipalities in KwaZulu-Natal. According to its financial and technical indicators, the municipality is doing fairly well. So in essence, the municipality is applying for an increase that is below guideline for all of its customers from domestic, commercial, and industrial. The only tariffs that made it come here are the time of use tariffs, which are at increasing at 8.61. And this increase is in line with the municipality's increase from ESCOM. And as indicated in the write-up, this is mainly because of that the municipality is trying to pass through some costs that are from ESCOM, hence the 8.61% increase. The municipality also indicated that it had consulted customers regarding the 8.61% increase, and thus far did not receive any pushback in this regard. Thank you, Chair. I recommend that the 8.61s be approved as applied for by the municipality to allow it to stay afloat. Thank you very much, Chair.
Thank you. Members, any questions? If not, can I take you to the decision that is sought is on page 382, paragraph 9. Can we approve this one by show of hands, members? Thank you, Madam Massetti. Thank you, Mr. Kize. I also support. The next one is Mpumalanga Economic Growth Agency by Mr. Nkuna.
Thank you, Chairperson, and good morning. Mpumalanga Economic Agency is not doing fairly well, as it's shown by poor record keeping, as proven by the qualified audit opinion that they got from the auditor. However, when we look at their cost, they are increasing, the costs are actually increasing by 7.93. However, the distributor opted to keep their increase to 7.4, which is supported given their poor performance. Our recommendation is on page 389. Thank you, Chairperson.
Thank you. Any questions, members? If not, can we go to a decision which is on page 389, the decision that is requested, paragraph 9, by show of hands, members? If we can support the decision that's sought. Thank you, Madam Massetti, Mr. Nkiza. I also support. Thank you.
Chairperson.
Yes, Mr. Nkiza.
Can I get something clear here?
Yeah.
That in this instance, we've got an application for above guideline, but the decision is to keep them at guideline, which is 7.47. And for that reason, it could have gone to the REC in any event, but because it's still within, it's decision to keep it within guideline.
It seems like that. Mr. Nkuna, do you care to respond to that question?
Yes, Chairperson, that's correct. Their costs are actually increasing by 7.3, but they've opted to apply for guideline increase. And we support the guideline increase because of their poor record keeping. We are actually trying to encourage them to keep proper record.
Okay,
Thank you,
but the question is, this should have, why didn't this therefore serve at the REC? Because it's within the realm of the REC then. Any reason?
I think from our side, the real reason is because this one, they are private distributors. They are not pure municipalities. Because we had that discussion to say why all the distributors are not going to ELS, because they have different cost structures. Thank you.
All right. Madam Massetti, your hand is up now.
Yes, thanks, Chairperson. Chairperson can also, the HODs come in very quickly here, because if members are put in a situation where we need to be very efficient in this meeting, HODs and executive manager must come in here, because I don't think that it is also proper to say that we are punishing them because of bad record keeping. That's not the issue. There must be an issue in terms of the effect on their financials. Even if there's record keeping, what is it that makes us not be comfortable? It's not just a question of record keeping. That is not the issue. There must be an issue why we are not allowing them, because if their financials are not looking good and there are some inefficiencies, we want them to correct those inefficiencies. So it is not the question of record keeping. And also we don't have the delegation matrix that says that if it's a private distributor, it will not be considered by the REC. I think the threshold is on the basis of whether or not the increase is above benchmark, or whether or not the increase is above the guideline increase, not because this is a public or a private distributor.
Okay, Mr. Sichotlo, as requested by Madam Maseti, care to respond?
Chair, if I can respond, Chair, I think we did promise the DLS about a month ago that there's a lot of fine tuning that we need to do in terms of the recommendations that we make. For example, Ms. Maseti has correctly, referred to the reasons that we are giving here, and I don't think they are actually, but there's been practice which we need to. In fact, the whole presentation of these the municipal tariffs they need to be fine-tuned and changed. But I take the point that the reasons that we have put here cannot be the ones that this application is here. That's all I can say from my side.
Okay, thank you. It does seem, though, that this is also one of these issues that we need. It's a governance matter that we need to deal with in a governance section. But yeah, clearly, and thanks for your comment, Mr. Mabuso. And it's a matter that you need to deal with, but it's a governance matter. Okay, members, can we then move on to the decision that is sought, which is on page 389? By show of hands, members, it is within guidelines. Thank you, Madam Maseti. Mr. Mkize, thank you, Mr. Mkize. I also support. The next one is Rustenburg. Dr. Konjelaya, I think this one comes with the cost of supply study. Dr. Konjelaya.
Yes, thanks, Chair. So this one is also another negotiated pricing agreement between Rustenburg and Extractor smelters. So it's based on the Megaflex again for them to be able to cover their purchase costs. So it's a Megaflex plus 7.5%. And because the Megaflex for municipalities is increasing by 8.61, we're also recommending. So the smelters take care of their own network, so they maintain their own network. They just want to recover the bulk purchase cost from Eskom on this one. Thanks, Chair.
Thank you, Dr. K. I think that is Madam Maseti. We got a question on this one as well.
It's approval, Chairperson. It's well presented. Thanks, Chair.
Okay, thank you, Mr. Mkize, support. Thank you for support. I also support it. Thanks, that was well presented. Now the next one, so it's this one that has got a, yes, it's over to you. It's actually got both yourself, Ms. Mabinya, and Dr. K. George Municipality, can present this one, please.
Thank you, Chairperson. I will present this one. Chairperson George is applying for a guideline increase. Last year, June 2021, NERSA approved the cost of supply study for George. So these proposed tariffs, Chairperson, are based on the approved cost of supply studies. And Chairperson, for some tariff categories, the municipality is are proposing guideline increases, above increases, and some they are proposing a decline. But all these proposals are in line with the cost of supply findings. And we'd just like to highlight, Chairperson, that There are 3 tariff categories where we've limited, because according to the COS findings, these 3 tariff categories are actually over recovering. So we've limited them to the guideline, and those include the consumer 1 or 3-phase capacity exceeding 20 amp on page 404. The second one is the small general consumer on page 402, and agriculture tariff 50 kVA to 100 kVA on page 413. So we've limited those to the guideline because according to the findings of the approved COS, those are actually over recovering. In addition to that, Chairperson, the commercial flex domestic tariff and the commercial flex and the domestic flex tariffs, these 2 tariffs are actually under recovering according to the COS studies by over 20%. So the municipality is proposing an above increase of about 20% for both these tariff categories. However, after discussions with the Munich has agreed to phase in the under recovery over a period of 2 years. So for these 2 specific tariff categories, we have limited the energy charges to a 10% to protect customers from a once-off phase-in approach. And we recommend Chairperson for approval. I just want to highlight, Chairperson, also that these recommendations that I'm making, it's excluding the SSEG and the wheeling in line with the decision that has been taken, because in this specific submission, the wheeling and the SSEGs are part of this submission. Thank you, Chairperson.
Thank you, Madam. I think it's also well presented. Any questions, members? If not, decision that is sought is on page 423. Can I see by show of hands? Thank you. Mr. Mkiza, is that approval or question? Thank you, Mr. Mkiza. Thank you, Madam Maseti. I also support the decision on page 423. It is supported by the cost of supply study, and that unfortunately goes all the way to page. Can I be assisted here? This is one of those where there are too many. Because it goes all the way until the submission on Dweebater's Globe, which is on page 652. Ms. Matumbu, if you can present that one, please.
Thank you, Chair. Last year, around the municipal tariff applications, Theavater School got its cost of supply study approved as well. And this year it is applying for an average increase of 7.47 in line with the guideline. However, when you look at some of the tariffs, some are increasing by the guideline, some it's above the guideline, some it's a reduction, but all of them are based on the cost of supply and are in line with the cost of supply. We've also indicated how each tariff is under recovering or over recovering, and we also checked how it is in line with the cost of supply, and we can say that all of the tariffs are in line with the cost of supply, and we therefore recommend for approval. Thank you, Chair.
Thank you, Madam. Any questions, members? If not, the decision that is sought is on page 673. There's a recommendation there by show of hands, members, if we can approve that decision. Thank you, Mr. Mkize. Thank you, Madam Maseti. I also support. The next one is presentation by Mr. Mdise, Mhopong, and Mudimule.
Thank you, Chairperson. Mudimule Mokopong is for current financial year. They are applying for cost of supply. They want to restructure their tariff. The reason they provided for restructuring is to improve on their profitability. They actually trying to build in the pricing signal similar to what Eskom is doing in their pricing. So basically what they are doing, they are currently introducing the time of use. They want to charge time of use for their electricity. So we looked at their cost, we analyzed their cost of supply, and then we were satisfied that it's aligned to the NERSA framework, which it starts with a revenue requirement. From there, the costs are functionalized and they are classified, and then they are allocated, and lastly, there is a rate setting. So when we look at the rate that they are setting, they are 99% comparable to the required revenue. And as one would expect, some of the tariffs are increasing by above the benchmark, some will increase by below, given the costs allocated to specific customer category and the profile related to that customer. We are therefore recommending for those tariffs to be approved and for the municipal to implement the COS rates. Thank you.
Thank you, Mr. Mdise. Members, any questions on this? If not,
Chair?
Yes,
Chair?
madam.
Thanks, Chairperson. Yes, I understand it is we also take into account the cost of supply, but we must remember that part of the cost of supply is not necessarily the cost per se, but it is largely driven also by the demand. If you look at the demand elasticities, those customers that are using a lot of electricity at a particular point in time. The example is this time of use. So it's not necessarily because they want to then make sure that they recover more profits from those that are using more electricity at a particular point in time. So it's not just driven by cost, but it is also the demand elasticities that are factored in to these cost of supply studies, and hence therefore they will restructure tariffs so that they improve on their profitability. Then our role as the regulator is also to strike the balance therefore on the part of customers in terms of the impact. It is not just a question of saying cost of supply, but we don't necessarily look into what goes into that cost of supply and how consumers are affected in terms of that, particularly because it's not just cost per se, the actual cost, but the demand elasticities that are built into that. Thanks, Chair, but I support the recommendation to approve. Thank you.
Thank you, Madam, for that enhancement. It is an enhancement and for noting the team. The decision that is sought is on page 726. Can we then, by show of hands, show approval, members? Thank you, Mr. Mkhize. Thank you, Madam Assetti, as you've also indicated verbally that you support. The next presentation is by yourself, Madam Mataku, and Nelson Mandela Bay.
Yes, thank you, Chairperson. Can I just request, Chair, that before I go into the tariff detail, I just request Dr. Konjolwaye to just give a brief overview of the results of the cost of supply study for Nelson Mandela Bay. This is a new tariff cost of supply application that we did. So before I go into the tariff part of it, I'll just ask him to quickly just do a brief overview. Thank you.
Okay, ma'am. Please proceed, Dr. K.
Oh, thanks, Chair. So the key findings, Chair, from this study are summarized on page 736 of 784. So that table there shows the subsidies that are currently built into the tariffs. The idea is to strike a balance between, so for instance, the subsidized customers and the ones that are paying a subsidy. So that's a key finding. And then the second key finding is around the cost reflectivity. So what the study shows is if the municipality was charging cost reflective tariffs, how would those look like? I'm just struggling to find this table. But as with all the studies, our main analysis is based on whether the study complies with the NERSA framework. But when we design the rates, or when we look at the proposed rates, we must strike that balance between affordability by customers and ensuring that any proposed changes are phased in, Chair. So if I may take members to lastly, one of the key findings, I think it's page, oh, okay, it's, sorry about that. So the municipality conducted its own study. So on page 780 of 784, we compared what the municipality did because we used our own model, and the findings are similar in terms of which subsidies are cross-subsidized and which are paying a subsidy. So, and lastly, Chair, on table 37, so these are the cost of supply findings. Basically, if all the tariffs were cost reflective, this is what the municipality should be charging. So they would have a retail component, net capital cost, NMD cost, and all those costs. But ideally, especially for smaller customers, your residential customers, you want to simplify your tariff and have a basic charge and maybe an energy charge. So I think that's all in terms of the findings, Chair, and the findings are aligned to the NESA framework. Thanks.
Thank you, Doc. If I may then go into the tariff part of it. Chair, just to indicate that Nelson Mandela Bay Metro applied for a 7.47% increase, and the statement from the municipalities that they would try and phase in all those tariffs where they are under recovering. Chair, on there's a figure 2 that's on page 736 of the submission that shows the results in terms of whether the different tariffs, whether they are under recovering or over recovering, and we see that mainly for domestic tariffs, the metro is under recovering to an extent of, I mean, the most under recovery for the indigent customers is about 44% under recovery, and for non-indigent customers, they're under recovering by close to 15%. Chair, the most tariffs are increasing by 7.47%, although there are those where the municipality was restructuring the tariffs, the increases are a bit more than the 7.47%. And for those where the study shows that there's under recoveries, those increases have been allowed based on the findings of the study. There's just one tariff, that's tariff 9, the medium business single rate, where in this case the municipality was also restructuring the tariff that came up to a percentage increase of 9.27%. This particular one, Chair, has been limited to guideline increase, mainly because in this particular one, the municipality is over recovering by 3%, and so the guideline increase has been proposed. Chair, that's about it in terms of tariffs. And to just also indicate that for this particular application, we've also included SSEG tariffs and wheeling tariffs. So, but based on the decision made earlier by the committee, that has been taken into account, Chair. The recommendations, Chair, are listed on section 11 of the submission, and we therefore recommend and request the committee to approve the tariff as presented. Thank you, Chairperson.
Thank you to both yourself, Madam Atlaku, and Dr. K. The decision, okay, first the questions, Madam Aseti.
Chairperson, to first indicate that I'm the resident of the Nelson Mandela Bay Metro, and also exercising my fiduciary duties here in terms of the decisions that are required by the energy regulator. So I thought that I need to indicate that for the record again, Chairperson, as we are about to take the decision. That also may limit the extent to which I may have the questions and suggestions, unless then I'm guided by our regulator legal counsel on this matter. Thank you, Chair.
Thank you. RSU, Mr. Chokwe, can you guide? I guess most of us are residents of one or so municipality. So, Mr. Chokwe?
Chairperson, thanks. It's actually not necessary, but it's good that Madam has just actually said it in passing. This ER takes decisions that affect the whole country, Chairperson, and like judges, therefore, the interest is not a conflicted interest. These are carrying out their duties. Thanks, Chairperson.
Thank you. In that particular case, I'm not sure if there are particular questions, members. If not, I think it was fairly well presented in that.
Chair.
Madam Assetti, yes. Questions?
Yes, Chairperson, it's well presented, I guess, because in some of these municipalities, it is the first time that we take decisions that are based on the cost of supply studies, and we have not had maybe an opportunity to assist the team in terms of how they should give effect to such studies and things that they need to question some more, so that they don't just rubber stamp the costs that are presented to us, because you still need to conduct your due diligence on the costs that are presented to us. Two things that are rising from this one is, based on the presentation, is areas where there are over recovery, and then also looking into the issues of affordability that were also mentioned, but also maybe the extent of cross subsidization, given the fact that in certain areas, they said that the municipality is under recovering, but there are also areas where the municipality is over recovering. Now, how do you strike a balance as the regulator so that you make sure that at least customers do not suffer, and some customers that are mostly those that cannot afford, they're also covered, whilst the municipality's profit is not compromised? I think that's sometimes something that the team does not come out clearly in all of these cases where you strike the balance and look into the issues of over and under recovery, but also affordability and the extent of cross-subsidization which is allowed in the Act. Perhaps we would have loved to hear them on that. What is their approach? Thanks, Chair.
Thank you. Mr. Mkiza, your comments, sir?
Yeah, thanks. With regard to the cost of supply studies, I think it would help. I appreciate figure 1, which shows the over and under recovery. It would actually also be helpful in the submission to juxtapose it to the increases or tariff adjustments for each. Just want to see the movement, how they move. I mean, in an anti-fashion. So it will for me it will be nice to have that presented in that particular way. And when people are talking, and when the municipality is talking about phasing in, the factors that goes to the cost of supply must also be clear as to whether they are fixed or could be variable in nature, in the sense that you may want to phase in a decrease, say for example, or where you over recovering, but only to find that actually you are no longer, there are certain factors that have changed such that you do not, the over recovery is not as huge as it was then. Because if you're talking of phasing in, it means we're also expecting applications in the following years. So it's important, so that is very clear, because I don't think that the municipality will always be in a position to do this cost of supply on an annual basis. So the factors, the adjustment in between will then be important. This is just me thinking. They can correct me if my approach to this is not okay. Thank you.
Thank you, Mr. Mtiza. Madam Atlaku? Okay, can you please respond to the questions?
I'll try and respond, Chair. In terms of the question posed by Ms. Massetti on what approach did we take in terms of those tariffs where there's over recoveries and in those instances where there's under recoveries and the extent of cross subsidization. Chair, what we did and how the municipality approached this was that if you look at the figure 2 where it shows the results of the cost of supply study, you see that the indigent tariffs, the under recovery for the indigent domestic tariff is as high as 44%. And I think in an attempt to also address the issue of affordability, the municipality, what they did, even though they seem to be under recovering by an extent of 44%, they still maintained the increase to just the guideline increase. In instances where there are over recoveries, the municipality have either limited the increase to guideline increase or some even below that. And how we approached it, Chair, for all those where there were under recoveries, we allowed those increases, even those that were slightly above the guideline, because of the findings of the study, we allowed those increases. However, for those where the municipality seemed to be over recovering, we did not allow anything over the guideline increase. An example of that I indicated is the medium business single rate tariff, where in that instance the municipality had restructured the tariff, and it resulted in a 9.27% increase. But because the results of the cost of supply indicated an over recovery, that has been limited in order to try and protect customers. That had been limited to a guideline increase. Chair. And in terms of what Mr. Mkhize had asked in terms of phasing in the tariffs, it would not necessarily mean that the municipality would have to redo the cost of supply study. But I think in the coming 2 or 3 years, the municipality would try and adjust the tariffs, either reduce those tariffs where there's over recoveries, and try and slowly phase in the increases for those that are over recovering. I hope that I've answered the question, Chair. Thank you.
Thank you, Dr. K. You want to expand?
Yes, just a quick one, Chair. So in terms of the cross subsidies, normally what the municipality will do will make proposals and take them to the council to say they want to keep the subsidy as it is, or they want to reduce it, and then it will be taken up maybe by business customers. So normally there's a cross subsidy policy that is in place for each municipality on how they will apply cross subsidies. And then on the issue of the cost, so the EPP requires that the cost of supply must be done every 5 years, or when there are significant changes to cost structures. So if the municipality, for instance, realizes that maybe in year 3 there've been some changes in the cost structures, then they can redo the cost of supply, or they have to do it every 5 years. So then the cost of supply will tell them that maybe their fixed component has increased or decreased, or whatever the case. Thanks, Jim.
Thank you. Maybe if I can just add on this quickly, that what maybe is also missing is the fact that the over recoveries are funding the under recoveries. So it's and that's the cross subsidy mechanism that essentially comes up. Members, I think it's been presented, and I must admit, Madam Maseti, I hear you around the system looking after consumers. Unfortunately, this is something that we are wanting to, in terms of the pricing mechanism, to try to sort out, because unfortunately our system is very supply focused. The cost of supply is just looking at the cost of the supply, but there is no equivalent approach that looks at the cost of the service to the consumers. So it's something that needs to be sorted out in terms of the law, actually, going forward. It is the real problem. Mr. Mkhize, I see your hand is still up.
I support. I might be having connection challenges later on. If you can just help.
Oh, all right. Okay. This is the last one of this on this batch in terms of Annexure 2. So hopefully we'll be able. I'm also going to have challenges after 12. So I was hoping that we'll be done by that. We're going to be load shedded at 12. So members, I think this is also very well presented with all of the challenges that have been raised. But can I direct you to the decision that is sought, which is on page 757, as indicated, Mr. Mkhize, that you support the decision on paragraph 11. Can I see your view, Madam Maseti? Thank you. You also support. I also support. That was the last one, members, in terms of Mr. Mkhize. Oh, yes, I had noted your approval earlier. That was the last one in terms of this batch. So we move on to the other applications, the ones that were above guidelines, the 4 applications. If we can move directly to that, members, and go straight to the City of Cape Town. Madam Mataku, if you can assist here, please, ma'am.
Yes, Chair, thank you. Without any waste of time, yes, we've prepared an RFD regarding the 4 applications which went for public hearing. These are listed on page 2 of the RFD, Chair, and the brief decision is also for the 4 is also listed on page 2, Chair. And in terms of detailed analysis for City of Cape Town, we'll ask then Ms. Mabenya to just take us through the application. Thank you, Chair.
Thank you. I was hoping, though, that you would read through. Maybe we can even have a discussion. For instance, the decision on that is that you want to restrict the increase to 7.47, right? Is that what in terms of the City of Cape Town? So that as we start, we actually start from that position.
Yes, apologies for missing that out, Chair. Yes, the decision on this particular one is to grant a 7.47, and the reasons for that are stated on page 5 of 45 of the annexure for City of Cape Town. Do I go on for that to the others, Chair, or wait until
it may assist, because the RFD is just one RFD.
Yes.
I think so. If we can deal with all of them, and then we can get the details, from each of the presenters. Thanks.
Thank you, Chairperson. We also had an application from City of Ekurhuleni, where the city applied for 9.61% increase. Chair, for this particular one, because the municipality at the hearing did not seem to have really concrete reasons or cost analysis supporting the above guideline increase, the decision for this particular one was to grant an increase of 7.47 on the revenue generating tariffs. There was also another application for Stellenbosch municipality, where the municipality applied for a 7.9% increase. For this particular one, Chair, the decision states that the net income which the municipality was requesting will not be sufficient to cover the capital requirement that the municipality put forth at the hearing. And for this one, the decision is therefore to allow additional revenue with a price increase of 7.9 as opposed to the guideline increase of 7.47. The finer details with regard to the decision that the colleagues will present, Chairperson. The last application was for Witzenberg municipality. Witzenberg had applied for an above guideline increase of 8.61%. However, the decision for this particular one is to allow the municipality an 8.34% instead of that 8.61%, because certain tariffs were limited those tariffs that were above guideline were limited. This decision was also made to protect customers from unduly high tariff levels, Chairperson. I think with that said, I would then hand over to colleagues to just make a brief presentation, Chairperson, starting with City of Cape Town by Ms. Mabinya. Thank you, Chair.
Thanks. As indicated, Chair, City of Cape Town is applying for a 9.6 increase, and which is above the guideline. And as Maria has indicated, we are recommending a guideline increase for those revenue generated tariffs. Chairperson, the municipality is requesting additional revenue of 71.5 million, and the additional revenue is required for the following: additional expense on the new bulk intake point connection fees payable to Eskom, for additional security for infrastructure, and then the last reason is for the correction of employee-related cost to cater for the 3.5% increase not budgeted for in the 2021-22 financial year. And the reason why we are recommending that the municipality must be given a guideline increase, it's because for the new bulk intake point, the city was requested to submit a signed budget quote with clear project timelines from Eskom, but the city has failed to submit this. They've just submitted an indicative cost estimate that does not have any timelines and that is not signed. And from our assessment, this means that there is no commitment or confirmation from Eskom that this project will go ahead or not in the 2022 financial year, 2022-23 financial year. So based on this reason, we cannot allow the city to pass through this cost to its customers. And then for the additional security, Chairperson, the city wants a dedicated team of law enforcement for the electricity business. This cost is also not supported based on our analysis because the city is already employing Metro Police officers and high external security personnel who are already on the city's payroll system. And over and above this reason, Chairperson, the cost is already provided for in the 7.47 guideline increase that NERSA has approved and as charges from other municipal departments. And the third reason why we are disallowing is because for the correction of the employee related costs, the guideline also takes into account for costs that are related to salaries. And therefore, NERSA cannot allow these costs to be passed through to customers, considering the current socioeconomic conditions. And over and above this, in the 2021 financial year, the guideline calculation also provided for a CPI salary increase of 4.4 in line with the Salary and Wage Collective Agreement as published by the South African Local Government Bargaining Council. And therefore, we do not recommend this additional revenue, Chairperson. And also, Chairperson, just to add, it's important to note that I think last week there was an article that has been published by various newspapers with regards to the City of Cape Town that it is owed about 7.5 billion in rates and services as at the end of April 2022 by its residents and businesses. Therefore, NERSA is of a view that if the city can have stringent measures to recover this money, then the additional revenue that they are requiring from NERSA of 71.5 million can be, they can get this money from if they can collect its debt and therefore not exceed the guideline increase. And Chairperson, I also want to note that there's a tariff, just not sure of the page number, on the small power user commercial tariff. This is a new tariff that the City of Cape Town is recommending for approval, but this is not supported because the city submitted its cost of supply on the 14th of June, and they've indicated that this submitted cost of supply has some technical issues that they still need to address. Therefore, we cannot recommend this introduction of a new tariff based on a cost of supply that has technical issues and that is yet not approved by NERSA. And therefore, we've requested the city to provide a final cost of supply study for consideration by NERSA that has no technical issues. And therefore, based on this information, Chairperson, I therefore recommend for approval. And just to also add that this guideline increase does not include the wheeling and the SSEG tariffs as per the decision taken earlier on in the meeting. Thank you, Chairperson.
Thank you. I'm not too sure whether I would have thought. Please, can we get a presentation on all the decisions, correct? But can we keep it slightly contained? Just hone in on the issues. For instance, in terms of the city of Ekurhuleni, we have not approved the higher increase, but we've limited them to 7.47. Let's just indicate very succinctly if there anything that has not been, something that has not been indicated by Maria up front, if you can add on to that. If not, let's move on to Stellenbosch so that we can actually reach a decision before 12 colleagues, if we can. Please proceed, but just so that I'll then open up the session to all of the, in respect of all four of these applications that are before us. Who's presenting the city of Ekurhuleni?
Ms. Masike, if you can assist with that, please.
Apologies. Sorry, I'm presenting from the phone, so I'm struggling a bit. No power since 10 o'clock. So City of Ekurhuleni applied for 9.61%. And they came to the public hearing. They could not exactly justify the reason for the 9.61 except for the timing issue. They were saying that the guideline was approved in May, whilst their council approved their budget in March. So we are recommending that in terms of that's not a good reason for above the guideline increase. In terms of the allowable increases. In tariff A, we are saying that because the municipality is charging the residents the same rates that Eskom charges to their residents, because there are boundaries where Eskom supply and boundaries where Ekurhuleni supplies. So we are allowing that, we are recommending that 9.61 be allowed so that the tariff mirror exactly what Eskom charges. And then in terms of tariff A, B, C, D, E, and F, where the tariffs are generating revenue, we're recommending that NERSA limits the increases to 7.47. Tariff G is a willing tariff. It's going to be noted in line with the earlier discussions. Tariff H is a future tariff. We are saying that this one, we can limit the increase to 7.47 because if it's a future tariff, by the time they submit their revised cost of supply study, we know exactly what costs are involved here. So it should be limited to 7.47. And then the tariff I is a special NPA wherein there's an agreement for an increase of 8.61. We are recommending that it should be allowed as requested. The same applies for tariff J. Chairperson, with this, we recommend that the increase to those tariffs that are generating revenue for the city be limited to 7.47%, and the rest where the municipality is just passing on costs from Eskom be limited to 8.61. Thank you so much. I will end there. Thank you.
Thank you. Perhaps, sorry, I'm just now concerned about this because we are dealing with specific tariffs within. So maybe if I can just maybe if I'm allowed to just reconsider the proposed approach, that we then maybe just go to the decision in Cape Town, the specific decision in Cape Town, and then make a decision there, and then move on to the city of Ekurhuleni and do the same, and then proceed to the other ones. Members, if I can maybe direct you to the decision that is sought in Cape Town, as it is indicated, I think we have indicated that they've been limited to 7.47, except where appropriately indicated. So can I maybe just ask members that we go to the decision on the city of Cape Town? If I can find it, where page it is. Ms. Mataku, please assist me. That's on page, it's on page 61 of 178. If we can maybe just make a decision on that and then move on. Apologies for the change. I think I was complicating issues. Decision that is sought for Cape Town is on page 62 of 178. I don't know if there are specific questions on this one. Madam Asset.
Chairperson, there was just one issue that Ms. Matlaku mentioned, which was the what is it? The non-approval of that proposed tariff because of the challenges with the cost of supply study, that it does not make sense. So are we also required to make a decision not to approve, or is just, you know, a decision that says because we say the members must not approve, we therefore reduce that tariff and bring it in line with the benchmark as well as the guideline increases? Are we going to take it like that, or are we going to be required to take a decision that says do not approve? Just that one clarity, Chair. Thank you.
Thank you, Madam. Can I take the Mr. Mkhize's question as well on this one? Any particular question with Mr. Mkhize?
Yeah, thanks, Chairperson. I will start off with the above guideline increases, just generally emanating from the submission. Require municipalities to report on a 6-month basis on how the additional funds are being used. If they may just relook that for the possibility maybe of making it 4 months or or so that you can have 2 full reports that you have analyzed, because that goes to the issue of saying colleagues should look at not working hard on these tariff applications once they've been lodged, but to make this a continual engagement process. Hence my appreciation also from Madam Mabinya in terms of looking at the the recent developments with regard to the city of Cape Town, to say that if they can recover those areas, actually, they would even be in a position to address some of the issues that they've raised that require funding. And the fact that despite several requests to the city of Cape Town for official correspondence with regard to the projects that they seek to undertake, none of that has come through. That for me, it is important for all our colleagues to have a continual engagement with the municipality. So for my side, I do support, and I have circulated my comments to Mr. Sichotlo in terms of other small gremlins that I think need to be dealt with. Thank you.
Thank you. Madam Mabini, if you can respond or...
No, thank you, Chairperson. I wanted to respond to Ms. Massetti's question on the small power user commercial tariff that the municipality is proposing. Ms. Massetti, we are recommending that the introduction of this new tariff it must not be approved by NERSA until the municipality has submitted a final cost of supply study to NERSA, because the one that they have submitted, they've indicated that it still has technical issues. Therefore, we cannot recommend a new tariff application based on a cost of supply study that is not final. Therefore, we propose that this specific tariff be not be approved by NERSA. Thank you.
All right. Thank you. Do you want to add on to the issue been raised by Mr. Mkhize?
I think the other issues that I've noted, I think there were issues of enhancement, but I think they talked to the overall RFD. I think Maria will be able to respond to those ones because they're not specific to City of Cape Town.
All right, thank you. Ms. Matako, do you want to add?
Yes, Chair. The issue that Mr. Mkhize raised on making the reporting to be a 4-month basis instead of 6 months on how the municipality spends these funds. This is a matter that we note, and I think going forward we will amend it to a 4-monthly basis and not 6 months as indicated. Thank you, Chair.
Thank you. Taking into account the guidance by legal earlier, please, colleagues. All right, colleagues, I've got 5 minutes. I'm going to be load-shedded, and I think if I get load-shedded, I'll try to connect as quickly as possible, but we're going to lose quorum. So hence why I was trying to get approval on this as quickly as I could, but I'll try to connect again. But if I do, Mr. Mkhize, please continue and chair for me. But with that, colleagues, I think we have been responded. Can I then take us to the decision that's sought in respect of Cape Town, plus that what has been asked by Ms. Massetti, that yes, we are therefore supposed to approve the actual rejection. So taking that including that in the decision, can I then perhaps members see by show of hands if you can approve that decision in respect of Cape Town? Thank you, Mr. Mkhize. Thank you, Madam Massetti. So you've got your decision. So can I then also, as this one has also been presented by Madam Masike, can I also then maybe invite comments or questions from members in respect of the city of Ekurhuleni? Mr. Mkhize, any questions there?
I support the recommendation. Also, I think it is also important to note that there was disagreement from the ratepayers, the stakeholders, in terms of the consultation having run smoothly. So I do support. Thank you.
Thank you. Madam Maseti, is that in support or is it a question, ma'am?
Chairperson, just I was trying to be efficient with this one. I've put the questions already as we're dealing with others, just to show that I've read and prepared. I've put the questions for City of Ekurhuleni on the chat. If they could try and respond to those questions, please, Chairperson. I mean, one is about there is a tariff that deals. I'm gonna be load shedded soon, so my iPad has switched off. There's a tariff that deals with is a tariff G with the Mega Flex. I wanted to find out if it includes the wheeling costs, because in the reasons column, the staff member has stated that there are issues of wheeling and all of that that are included in that tariff. So I wanted to get clarification on that, given the earlier explanation by Mr. Moratti. And also the other question is about us approving tariffs that are higher or supporting the higher tariffs for the reasons of trying to encourage customers to switch to another tariff category, of which tariff category is a bit high. My question is that proper? Is it something that we want to do in that manner as the energy regulator? So there's a number of those, Chairperson, including the protection study cost by Witzenberg. I'm just dealing with the comments, Chairperson, by Witzenberg municipality, which adds an amount of 9 million, for instance, into the tariff. And I'm asking myself, is this an insurance cost? But it does not appear to be. It is just to come up with a cost for instances of vandalism into their infrastructure, and now customers must pay for that. I'm questioning that as well, Chairperson, with Witzenberg. Those are all my questions with the remaining municipalities. Thanks, Chair.
Thank you, Madam. Ms. Masike, if we can deal with the questions, if any, that are in respect of the city of Ekurhuleni, please, so we can go for a decision there. Madam Masike.
Sorry, say I was muted. The first question about tariff G, yes, it is a wheeling tariff, but it is existing. It has been previously approved, yes. So it includes the wheeling costs, just to be specific to what Ms. Masset is asking. And then, okay, the other question was, is it proper to increase a tariff as a way to punish customers? Ms. Massetti is not mentioning which tariff. City of Ekurhuleni 2.3 for low cost season. I don't know which tariff Ms. Massetti is referring to.
It's a number of them. High, what is it? Low season, high season. There's a number of those different categories of those tariffs. If you check the City of Ekurhuleni.
Okay. I'm not sure if they are trying to punish any customer, madam. We are limiting the increases to 7.47. So I'm not so sure if there's any punishment there.
Okay, but the issue that we are limiting them to 7.47. So yes, if we can move off that one. Thank you, madam. Is there anything else on the city of Ekurhuleni? If none, members, can I then take you to a decision on the city of Ekurhuleni, please, members? Unless there are any additional issues. Thank you, Mr. Mkhize. You have indicated your verbal support. Madam Massetti, would you support the decision, which is on page 102? So this one is just limited. They're limiting everything.
Yes, Chairperson, but the point is still not answered. I mean, we are taking customers from one category to another category, which is the high cost category, then that for me, I'm saying, yes, you are punishing them because you say, move away from this tariff, go to this tariff category. And for that, you're introducing a cost. It's like you're saying people must move away from electricity generated from coal and move to an electricity generated by renewables. And for you to accelerate consumers' behavior and the switching, it means therefore make coal, gas, and the others expensive so that people then go to the next. But here is slightly different. So that is just that issue of accelerating the switching from one category to the next. I support Chairperson because I don't want to hold the meeting back, but I think reasons must be very clear so that we're comfortable when we take decisions, Chair. That was just the issue there, Chairperson, for a number of those tariffs. Thanks.
Thank you, Madam. Noted, and I also support. Can we then move on to Stellenbosch, please? Ms. Botha, if you can present that succinctly, please. You note and also respond to the questions on the chat as we are presenting.
Thank you, Chairperson. Stellenbosch municipality have applied for a 7.9% increase, and they have served at the public hearing for that. Some of their reasons include their overhead costs that the municipality have incurred.
Your connection is really bad, ma'am. Your connection is really bad.
Not budgeted for.
Your connection is horrible, ma'am. Your connection is absolutely bad. Madam Atlaku, do you care to assist, please?
Chair, I'd suggest that maybe we move on to Wurttemberg while I contact Ms. Botha.
All right. I'm going to mute her and please talk to her. And then let's move to Wurttemberg, please. Please contact her. Let's go to Wurttemberg, members.
Thank you, Chair.
Yes.
Winterberg is applying for an average increase of 8.61, which is above the NERSA guideline. And it stated that its reasons is that it wants to implement a protection study worth 9 million, which it will implement over a period of 3 years. And it also indicated that it has aging infrastructure, which it wants to replace. And it may if I can direct members to page 146 of 178, the municipality provided its budget for the next coming 3 financial years, and can be clearly shown that the municipality will be operating at a deficit, in spite even if we decide to grant them the above guideline increase today. So it's tariff. When we look at their tariffs are below the benchmarks. Some are within the benchmarks, and there was only 2 tariffs that were above the benchmarks, which we then limited it to the guideline increase of 7.47, and we therefore recommend for approval. Thank you, Chair.
Please deal with the questions posed by Madam Massetti on the chat, please.
Sorry about that. Can I quickly look at the question? Sorry, sir. I was reading the question from Ms. Massetti. Apologies about that. In terms of the insurance, I will discuss that with the municipality. I can check that with the municipality in terms of the possible vandalism. However, there were the above increase was mainly for the protection study and the replacing of the aging infrastructure, not necessarily in terms of the vandalism. And the 9 0.9 million they are asking for will be then written off in 3 years. For instance, they indicated that already awarded a tender to a contractor of worth 2 million to start with the replacing of the equipment for this coming financial year. Thank you, Chair.
Thank you. A quick follow-up, Madam Maseti.
Yes, Chairperson. I don't think that they asked the questions directly, and I've put the questions earlier on so that I can save time. The question is that this protection study and the implementation thereof, it attracts a cost of 9 million. And I'm saying that study came as a result of that protection thing, came as a result of vandalism. And I'm saying if now they come up and say we still need to roll out this, and here's the cost. I'm saying why can't that be accommodated through insurance as opposed to making consumers to pay for such things? So it's either insurance or this protection study if it is justified. I was asking, is this a kind of a cost that the regulator, a direct cost of supply of electricity, that the regulator must allow the municipality to recover? And is that tantamount to insurance, which then the regulator can allow? Really, the question is straightforward, and it has to be dealt with in that manner, Chair. Thank you.
Thank you. Can we then kindly assist?
The study is to protect the new equipment which they want to, or the infrastructure which they want to replace. And that is why they are bringing it to NERSA. And the study will also help to reduce damage to the new electrical hardware, infrastructure. And it will also ensure that the municipality supply to the consumers is also efficient, and it will also help in the reduction of the municipality's energy losses. Thank you, Chair.
Thank you. I hope, Madam Maseti, the responses are adequate. If so, can I direct members to the decision that is sought, which is on page 177 of the submission? And if we can move on that, members, by show of hands, if we approve. Thank you, Mr. Mkhize. I also support.
Chairperson, I approve, but I think it's important to just clearly talk to the relevance of whatever cost that you include. Because the question raised was actually talking just to that, to say, is it really relevant? Must all of it be included? Or, to have a view in terms of, so in future, if there's some cost, the proper justification for the inclusion of those costs must be articulated. Thank you.
Okay, there is a concern, colleagues. But I do have my major concerns on this because we regulate tariffs. We don't regulate revenue in this particular case, unlike ESCOM. So, but I do not want to raise this here because a lot of this is about revenues. But the question is, we are regulating tariffs. To what extent do we include this? So it is a major concern, I think. And what we are asking is the relevance as well. And that's what Madam Maseti was also asking, is the relevance. And also, is this the best way of protecting this? Is it not protected by, are these assets not protected by insurance? In which case, if there's a
Mr. Choko, can we proceed so that we can just protect the meeting, and I can just support the decision so that we move on from this matter, but flagging the secretary to just flag that issue of ensuring that we do not add costs that are not relevant, and then consumers are made to pay for those costs that are not relevant. Just to assist there for Mr. Kumede, so that we can go on to the next issue. Thank you.
Chairperson, I missed the question. I'm sorry.
Oh,
sorry, Mr. Kumede, you are in now.
I'm back. I'm in because I know that if one of us goes, then we actually lose quorum. So I'm back, connected by my phone as well. Thank you. We can proceed.
Okay, Chairperson, I was just saying I'm in support of the decision so that we can be able to move forward, so that the decision can also receive majority. Thanks, Chair.
Thank you. I also am in support. Mr. Chokwe, you wanted to add something? Apologies, I cut in. You're still saying something?
Chairperson, no, I had a challenge. I didn't hear what Mr. Massetti was talking about. I'm fine. Thanks, Chairperson.
All right, thank you. Can we now move back to Ms. Pumla Wather, please, on Stellenbosch? Hopefully, she would have a better connection now.
Thank you, Chairperson. Apologies for earlier. My load shedding kicked in as I was presenting, so I switched now to hotspotting.
Okay, much better. Apologies for that.
Okay. So Stellenbosch municipality have applied for an overall increase of 7.9%. One of their biggest reasons, apart from their expenses, is the fact that they need to build a substation to accommodate the network that they have taken over Drakenstein. As mentioned, I think earlier in the discussions that Stellenbosch and Drakenstein had an agreement for Stellenbosch to supply some of Drakenstein, some of their customers that are based in Drakenstein. So after the takeover, the Stellenbosch appointed an independent consultant to carry out an electricity master plan to determine the condition of the network that they were taking over. So the findings were that the entire network required urgent attention as it was found to be in a dire state. So from this, the capital projects plan was recommended by the consultant that requires for them to build a substation to accommodate this extended network now. And in assessing their financial position, which is detailed in the table, I think listed in page, let me just see what page it is on the submission. So I've done a financial assessment for the municipality on the table on page 113 of 178 of the submission. That sort of gives an overview of what would have been of the municipality's revenue had they been approved at 7.47% and what would be at 7.9%. And what this tells us is there's a revenue variance of about 3.49 million that they would be collecting with the additional 7.9% revenue. And then looking at their expenses of about 711 million versus their revenue, their net income of 141 based on the projected expenses is not sufficient to carry the 27.45 million that is required for the capital project plan for the next financial year. And so my recommendation was that approval be given for Stellenbosch at 7.9%. Thank you.
Thank you. Members, any questions for the presenter?
Chairperson, may I go quickly?
Yes, please, ma'am.
Chairperson, I think my issue is with this additional cost of building the substation, given the fact that, yes, the two municipalities got together, and now it will mean that existing customers of the Stellenbosch municipality are now going to incur costs for the infrastructure that was not servicing them. It was servicing customers that are in another municipal area, and now all of the customers existing and the new ones that are now migrating into this one municipality, all of them must now bear the cost of that poor infrastructure or bad infrastructure. So I just wanted to check whether the customers were consulted and they were comfortable with that cost, first of all. terms of the disclosure of that cost that they must carry, and also the extent of the cost that now customers must absorb. And maybe the second thing that I would like to find out is whether, as the regulator, we have any development plans or upgrade plans from this municipality, of which upgrade infrastructure plans will then show the cost as well as the budget that has been put aside for it and the execution of that project, so that we can see for how many years we are supposed to keep this at the back of our minds and allow the cost over those years, and for customers to bear those costs. I think it will be a fair assessment from our side to have that kind of information as we approve costs that include building of the substation. Thank you, Chair.
Thank you, Madam. No further questions from members. Ms. Botha, if you can respond, please.
Okay, thank you for the question. To answer on the customers being consulted, yes, the municipality conducted a public consultation process between the 4th and 28th of April 2022, and all the community members were in agreement with the plans of the municipality, because not only this network will the network assist the Drakenstein users, but also the locals in Stellenbosch as well. So it was highly supported by the community members. And then in terms of a plan, yes, the Stellenbosch municipality, after the public hearing, have provided NERSA with a detailed plan, a 10-year plan, as well as the budgets and some funding alternatives that they will explore as they go along. Thank you.
Thank you, Madam. Any further questions? If not, members, can I direct you to the decision that is sought is on page 140 of 178? Can I direct you to the question that is the decision that is sought is on page 140 of 178? By show of hands, members, if we can support that decision. Thank you, Mr. Mkhize. I also support. Madam Massetti, thank you, Madam Massetti.
Supported, Chairperson, with the submission of those upgrades and the plans, so that we can see the cost, because it might be recovered over 3 years or so, and therefore, next year we might be faced with the same thing. But what's her name? Upumla has not responded to that question about the regulator having those plans, having looked at the budget, having looked at the timeline for the building of that substation. Thanks, Chair, for the submission of the plans and the cost, as well as the schedule for that, Chair, for our monitoring, and also for the possible cost escalation. I know that we are not responsible for construction of any infrastructure in electricity, but there are costs that arise from that when that infrastructure needs to be operated. Thanks, Chair.
Right, thank you. Thank you for the decision. Members, this brings it to the end of the submissions that we were dealing with today. If we can then stop the broadcasting as we go into item number 7, notices and personalia. If we can. Okay, thank you. If we can move to item 7, please. Any matter under item 7? Ms. Kapika?
Chairperson, thank you. Good afternoon, Chair, members and colleagues. I will just highlight the public hearings that will be held on the 1st of July. The application by Engen Petroleum for the conversion of its refinery to terminal. The public hearings will take place in Osterville Community Hall in Durban, and also they'll be held virtually, so to be a hybrid model, Chairperson. Secondly, Chair, just to indicate the forthcoming events, that there's an AFUR 50th Executive Committee meeting that will be held on the 26th of July.
as well as the executive committee meeting that is scheduled to take place in Maun in Botswana on the 15th of July. Thank you, Chair. Those are the only highlights. We will update as we receive more or additional official notices, Chairperson. Thank you.
Thank you, Madam Kapika. I'm not sure if members, there's anything else in terms of the notices that we want to bring to our notice. But there is one thing that I wanted to raise, members. It's a request. We had a special ELS on Friday, and we agreed that we're going to have we're going to put the matter that was discussed on a. I know, Madam said you were not there, but we're going to put it on a round robin. We need to actually publish that consultation paper, if approved, by tomorrow. Otherwise, we'll definitely miss the deadline that we have in terms of the court order that we have, joint court order that we have with ESCOM for the 30th. So my request is, members, please consider, as discussed on Friday, if you can consider. I noticed that it's not been published yet. I don't know where the holdup is, but if I'm talking about that round robin, firstly, I really request members that you consider that round robin and actually effect your decision. It is a plea that I have, please. If we don't do that, we will definitely miss the 30th of September deadline, as which is in the court order. So with that would be my last ask, members, and it's intended to address a lot of the issues that we actually talked about earlier. Madam Aseti.
Thank you, Chairperson, for I was not aware, but thank you for letting me know about that. I just wanted to then say that I think it will be helpful if the Secretary can send us SMSs, Chairperson, as soon as that document or that submission is uploaded on the board pad, so that we can be able to respond quickly to that, and so that we don't miss the deadline. I think it will be proper if that is done. And then again, Chairperson, I think so that we secure the majority decision, since we don't have another member, and I don't know if the committee has been rearranged in terms of the number of members of the committee, so that we know how many approvals, or how many, members are supposed to sort of approve for one to secure a majority decision. I think that will also help a great deal, so that there is no delay in now processing, the decision once we have secured sufficient signatures and approvals for that particular submission. Then lastly, Chairperson, I don't know if Ms. Kapika could then perhaps if she has got any update on the status of tomorrow's meeting of the ER, if she can notify us about that. I know that there was a possibility of cancellation of the ER meeting. If she has been updated, if she, I would request that she informs us about that. Thank you.
Thank you. All right, Mr. Mkiza, before we get responses, yeah. Mr. Mkiza.
Yeah, I think that.
Sorry, Mr. Mkiza.
The application that you talked about is actually approved by ELS and then sent to ER for noting. So it should not be a hold-up, in my understanding. And then I have also received an email to the effect that there's a cancellation of tomorrow's ER meeting. Thank you.
Thank you, Ma'am. All right, all right. Thank you, Mr. Mkiza. I was requesting ELS members. I understand the decision is actually an ELS decision, and the meeting that we had was an ELS meeting of the 1st. So it's that we need a round-robin decision by the ELS members. So that's what I'm requesting, that the ELS members actually make the decision. And Madam Aseti, we still remain 5, because all members of ER are actually members of the ELS at this stage. So there are 5 members of ER, all of them are actually members of ELS as we speak. And And yes, there has been a cancellation. There's been a notification that has come through on email that the ER meeting has been cancelled or postponed to another date. I'm not sure if there are any other comments, members. If not, I'd like to thank you all. These municipal tariffs are difficult because of the timing issues that we have, that we are also hoping that with the proposed changes to the pricing mechanism, that these issues will also be dealt with in terms of, so we can meet for the first time the March the 15th deadline in terms of municipalities finalizing their budgets, which we have not met ever, as far as I know. So if changes are effected properly, we should be able to meet that for the first time. Perhaps not next year, but we'll be on progress to actually meeting that going forward. We must improve a little bit, but I'd like to thank you, members, for the time and effort in reading through all of these materials, and also like to wish Advocate Sithole a speedy recovery from her flu. And Mark, I saw your hand. Apologies. Before we close.
Yes, Chair, members and colleagues, profuse apologies for the interruption, but we've just received between myself and Eleazer the email confirming that the round robin has been approved, and he's in the process of uploading it, and that's why I'm alerting members that while he's busy doing that, that should be on your board pad within the next few minutes. Thank you.
Thank you, Mr.
That's the round robin. Yes.
Yes, thank you, Mr. Bia. All right, members, thank you for your participation, and we would like to bring this meeting to a close, and the meeting is adjourned. I thank you.
Thank you, Chairperson and members and everyone.
Thanks, Chair.
Thanks to everyone, Chair, members.
Thank you.